Ms. Zenda.
Good morning, Your Honor. Allie Zenda on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of Public Defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
Ron Crane on behalf
I got
of the Defender's Office. She's
She's got it. She's got it.
Hannah Mackey on behalf of
Just do whatever.
Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
Permission to practice is granted. I appreciate you're just taking charge. Go ahead.
Your Honor, we waive any conflict between this honorable court and our office. If any conflict were to arise, we waive that conflict so that this honorable court can hear these matters. Thank you.
Court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. People of the State of Michigan versus Imbaye, is it India?
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning.
Good morning, Your Honor. Assistant Public Defender Kasim based on behalf of Mr. Mbaye Ndaye.
Is he here?
I have not spoken with him, Your Honor. Ndaye? Your Honor, I have not had any meaningful contact with him, unfortunately. Was going to be asking for an adjournment. There is an offer. He did pay about $3,000 to get out. There was an agreement between the Attorney General's office and I, but have not been able to reach him.
He's not here. How much is currently owing on the child support council?
So, Judge, my understanding is that the defendant posted the bond. It has not yet showed up in the child support system, but his current arrearage, Your Honor, is $20,287.86. I'm wondering.
You said 20? I'm sorry. You said 20,000?
$20,287.86.
Thank you.
Judge, I know you have a mechanism to have those bonds. Do we know whether they're processing that bond over to the child support case?
They should. Yes, our mechanism is that the order would read to pay that bond over. And I think that has, I just want to make sure that the bond form indicates that. And it does, to send over to circuit court. So he's paid about 3,000, a little over 3,000 of that amount.
That's correct.
So it's about 17,200 that's still owed.
That
So
would be
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $17,200. That's cash to be paid to the circuit court if posted. That warrant will issue immediately.
Thank you, Your Honor.
And Your Honor, will that be an immediate bench warrant? And do you need the AG to prepare and submit it, or will the court handle that?
No, we will handle it, and it's an immediate bench warrant.
Very well. Thank you very much, Your Honor.
All right, thank you. Court does call the case of the people versus Tevante Davis.
That for the people.
Morning, Your Honor. Alex Warren, Green on behalf of Mr. Davis. Mr. Davis, can you state your name for the court?
Tevante Davis.
All right, thank you.
Your Honor, at this time, we are asking the court to set this matter for preliminary examination.
And all discovery is complete.
I believe so, Your Honor.
And which one are we on, July 20? Really? 12 years
Oh,
out?
I'm sorry. It's a week from July 1st.
I thought so. People have their witnesses available July 1st. Preliminary examination in person will be set July 1st, 2025. 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Alan Belaloo.
Good morning, Judge Lawrence H. Margolis with and on behalf of Alan Belaloo. Alan, please state your name.
Alan David Belaloo.
Judge, this is a referral, we hope, to the Veterans Court. He has been accepted into the court, and we are prepared to go forward with a plea today. If Your Honor will take it, he has been advised of his rights. He has signed a waiver. He is also prepared.
What is he pleading to?
Disorderly.
I don't know. Your Honor, I don't know if different other people, Your Honor, I don't know if Your Honor had a chance to sign the referral and if that paperwork.
I have the referral that I will sign off on, but I don't have a plea form. I don't have anything.
Then we aren't ready for it. We needed you to sign it. So that's what we needed.
Yeah, that was the one thing I was waiting on. Was hoping we could do it this morning, but I don't obviously mind
Do
passing.
what this morning?
Sign the plea form. That was the only thing that was not prepared.
I don't kind of need that.
I was hopeful that Ms. Douglas could.
Okay, what am I doing? Because otherwise I'm just gonna do what I'm gonna do.
I have an email at 9 a.m. with maybe the information that you're looking for.
At 9 o'clock this morning?
Yes, I have not reviewed it. So Your Honor, he was trying to get him referred to Veterans Court. I had not received confirmation that he'd been accepted, and that's why I didn't do the plea form, because he needed paper.
No, I got you, because I just signed off on the referral. So I can't really do anything.
And I apologize, Your Honor. I was under the assumption that the emails that I had provided from Mr. Graveline stating that he had been accepted into the court and that this was going to be pled today was going to be sufficient, but
Probable cause in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. You guys get your stuff together and then I'll deal with it.
Thank you, Judge.
Court does call the case, People versus Larry Hickman.
Judge Kennedy, after people, Your Honor.
This was the.
Yes.
Good morning, Your Honor. Student attorney requesting Andra Savvy requesting permission to practice pursuant to NCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli, representing Mr. Hickman, who is present in person today.
Permission to practice is granted.
Thank you, Your Honor.
I guess the first thing we need to take care of is there were additional counts added, counts 3 and 4. I think we got the counts straight. Have you reviewed those with your client?
I believe Ms. Ikiri Akinruli has reviewed those counts with Mr. Hickman. Yesterday? No. The new counts, were they reviewed with you yesterday? No.
Where is Miss Akinruli then?
I'm not sure, Your Honor. I believe she may be in another courtroom at this time.
Well, has anybody gone through the other counts with him that were authorized? Or you don't know? I'll take that as that I don't know. Huh?
Yeah, I apologize, Your Honor. I cannot provide an answer to that at
Take
this
it back. I'll pass the matter. We'll have to bring him out later. I have to go through those other counts. Court does call the case of the People versus Brandon Clemens.
Good morning, Your Honor. Attorney Jonathan Paul for Mr. Clemens.
Clemens, can you state your name, please?
Yes, sir. Brandon Clemens.
And I'm gonna. That's okay. My copy. Okay, thank you. All right.
I wasn't sure you were going to do it.
That's the one report that I got
Yes.
last minute. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilt. Well, is he going to be pleading guilty or no contest? Because otherwise I've wasted my time reviewing a plea.
Your Honor, he's pleading guilty.
Pleading guilty to the charge of operating while intoxicated with an occupant less than 16, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that
Yes.
correct?
Yes, sir, that's correct.
Yes, Your Honor.
Clemens, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
State your name again for the record.
Brandon Clemens.
Put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor. Yes, Your Honor.
All right. And understanding all of that, well, and I'll also indicate to you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge. Need a name. Before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor. Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor. Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Pardon?
I currently have a sober breathalyzer.
You're not right. Are you under the jurisdiction of any other court, sir?
No, Your Honor.
All right. Have you ever been to prison for longer than a year?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor. No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor. Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor. Yes, Your Honor.
All right. And you understand that if you commit any type of misconduct between the time of this plea and the time of sentencing, that you would not be entitled to withdraw your plea unless allowed by the court for a good cause. You understand that?
Yes, Your Honor.
You also understand, sir, that if you do commit misconduct during that time, the sentencing judge would not be bound by any recommendation or evaluation.
Yes, Your Honor. Yes, Your Honor.
Is counsel aware of any other pleas, inducements, or threats that have led to this plea?
No, Your Honor.
No, Your Honor.
Counsel, I didn't hear you.
No, Your Honor.
All right. Sir, on the date of April 3rd, 2024, at the location of Liberty Street near Maple Road in the city of Ann Arbor, Washington County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had drank heavily the night before, and then the day of that morning, I had about 2 twisted teas. So I think my blood alcohol was mostly from the night before of me drinking heavily.
Were you stopped by the police or was there an accident?
Was stopped by the police. There was
Why did they stop you?
I did bump a little bucket inside of the store, but they stopped me because of the driving that they had witnessed.
Are you disputing the right of the police to stop you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station or the hospital?
I was taken to the station, Your Honor.
Was there a data master or breathalyzer test of some type?
Not on my end, Your Honor. They took me to the police station, and then later they took me to
So was there a breath test or a blood test in this case?
Your Honor, it was a blood test of 0.24.
Did you take a blood test, sir?
Yes, Your Honor.
What were the results of that blood test?
0.248, Your Honor.
0.248? Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Was there an occupant in that vehicle
You broke up, Your
besides
Honor.
you?
Yes,
Pardon?
there was another occupant in the car, Your Honor.
Who was that?
That was my girlfriend's son.
And how old is he?
He is currently 6.
At the time, how old was he?
He would have been 5 years old, Your Honor.
Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea. 2 count 2, count 1 is dismissed. The pre-sentence investigation and screening and assessment is ordered at 15th District Court. Sentencing in this matter will be
July 14, 2025 at 8:30.
July 14th, 2025, 8:30 before Judge Perry.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you.
You can sign off, Brandon.
Thanks.
Court calls the case of the people versus Michael Patterson.
Can I be executed, Your Honor?
I have 2 cases. Second, really? Hang on a second.
Good morning, Your Honor.
Pardon?
I said, good morning, Your Honor.
Not really, but thanks. Good morning to you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patterson. Today is the date and time set for the probable cause conference, Your Honor.
Yes, in both matters.
Set up an examination.
What's that?
Set up an examination covers the officers.
Oh, that's from the prosecutor?
Yes.
I didn't I go to the hospital. So today, I would like to be concluded from this situation, in this case, just to be further admitted into the psychiatric hospital. He already ordained that.
We'll do that as part of the bond. Your Honor, today, there are no offers from the prosecution. My client will respectfully request that this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
You want preliminary examination in both cases, sir?
Yes, please.
To your knowledge, I'll discover his complaint.
To my knowledge, yes.
People have their witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor. As to bond, we're asking for a modification. My client indicates that he has already been determined to be released to,
I'm sorry?
To Havenwick, on Arbor Hills, Havenwick Hospital for psychiatric treatment.
Arborwick, Haven Hills Hospital, we're asking that his bond in these cases allow him that similar release to, what's saying the name of it again, please?
To Auburn Hills, Havenwick Hospital.
Auburn Hills, Haven.
For treatment?
Yes, please.
And you say he has that in his other cases, or?
Yes, the last time I was here, that's what I was before you, Judge Simpson, and you ordered for me to go there.
I think I ordered release to inpatient treatment.
That's right. That's what I want.
But I think did we already order it?
Well, it sounds to me like.
Yeah, on my last court date, that's what was, that was ordered by, you personally.
Okay, I don't have an order. If it's a release to inpatient treatment, I am not going to have an objection whatsoever. So where's Ms. Yagi? Ms. Yagi has an order that she has prepared that probably all of the public defenders should use, that I'd be more than happy to sign off on, that I've signed off on for the last 5 to 10 times for her.
I know Ms. Yagi will happily share.
Mr. Patterson.
Thank you, Ms. Yagi.
Because we are one happy family.
I don't know about all that. All right. So at this point, what I'll do is his bond will continue. And once I receive that order, I'll sign off on it.
Thank you very much.
All right. Thank you.
Thank you, brother.
You're welcome.
Okay, to whip him into shape. Court calls the case, People versus Mary Collins.
Andrew Bannon for the people. Good morning, Judge Coverell, on behalf of Mary Collins, is approaching the podium. And Mrs. Collins, please introduce yourself to the court.
I'm Mary Collins.
Thank you.
And Your Honor, today's the date and time set for probable cause conference. I have spoken to Prosecutor Bannis. We are working on a resolution. I do have a adjournment form for the court's file.
Probable cause conference in this matter will be adjourned to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, sir.
Court does call the case, People versus Lakita Roberts.
Andrew Bannis.
Have to start working.
Hannah Mackey on behalf of Mrs. Lakita, who's approaching to my right. Please state your name for the record. Your Honor, we're respectfully requesting an adjournment. We believe that we could discuss a possible global resolution in her circuit court matter as well.
So she has things in circuit court.
She does, Your Honor.
And when's her next date in circuit?
Don't know that
Well,
one.
you're gonna do a global resolution. Don't you think you should know that? I'll wait.
Your Honor, I see a case, according to X jail, a circuit case scheduled for 6/25, June 25th.
June 25th, Your Honor, is the date.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond continue.
Thank you.
Court calls the case of the People versus Bianca Rao.
Andrew Bannis for the people. However, on behalf of Ms. Rowell, who's approaching the podium. Ms. Rowell, please say your name for the record.
Bianca Rowe.
So, thank you, Your Honor. So we are, today is the date and time for probable cause conference. We have worked out a resolution. I've provided documents to the prosecutor, Mr. Bannis today, and I have a few more that I'm going to email that Ms. Rowell provided for me today. We just need to have first APA, Burton Harris, look at these documents. So we are asking for a brief adjournment, hopefully the last.
Probable cause conference will be adjourned July 3rd, 2025.
Thank you, Judge.
9 a.m. Bond continue. Court calls case People versus Thomas Vasher.
Andrew Bannis.
And Alex Warren Green on behalf of Mr. Vasher. Mr. Vasher, can you state your name for the court?
Thomas Vasher. Are we gonna get breakout room or something?
Oh, Your Honor, I went to the jail last night and
Yes, you did. He wasn't there. He's in the hospital.
he has been transported to the hospital.
Yes.
So I'm asking for an adjournment. The people generously did extend an offer. I want to discuss that with Mr. Vasher. And if I may ask on the record, Mr.
Now-
Vasher, do you anticipate when you'll be discharged and returned to the jail?
No, actually, they just talked to me and I plan on staying here. They they need to run
Okay, well,
different tests.
Mr.
and see why
Vasher, call the
legs are-
public defender's office if you can, and Your
Well,
Honor,
how
I'm
come
respectfully asking
Room and
for
you
an
can
adjournment.
explain, or can you address my bond at least? Because I'm here on my bond's been violated because you guys.
Mr. Vasher,
while I was out.
Your Honor, I'm requesting an adjournment to the next available
Well,
date so I can talk
to
to
address
him.
my bond. I'm asking you that.
I'll give him an early date. That way you can go talk to him and see exactly what it is his complaint is. June 26th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
I want a new counsel.
Court calls case People versus Julius Holston. That's on.
Good morning, Your Honor. Edward Rubis on behalf of Julius Holston.
Good morning, Julius Holston.
Your Honor, there was a resolution that was worked out this morning. It would be a no contest plea. I have a plea form if the court's able to allow that. Otherwise, we'd be asking for an adjournment.
No contest. I haven't even read a report.
I understand.
They're supposed to get to me at least 24 hours. I don't mind doing the work, but I'm not going to do it on this day.
Okay.
So I'm going to put it over and then I'll take your plea.
Okay.
But I'm not going to do it. I'm not going to doing that today.
That sounds like a plan.
Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Demarius Tubbs.
Andrew Bennett.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051 on behalf of Demarius Tubbs. Mr. Tubbs, please state your full name for the record.
Demarius Tubbs. All right, first order of business is I need a substitution of attorney filed. Mr. Martell, I'll let you go ahead. I realize you filed an appearance, but I think you know the court rules require a substitution of attorney.
Yes, Judge.
All right, what are we doing today on this?
Judge, it was my expectation that charges would be filed federally by now. I have not received any. So Judge, discovery is complete. I'm asking for an examination date, please and thank you.
I didn't hear any of that. You need a better microphone.
Forgive me, Judge. Discovery is complete. We're asking for a preliminary examination date.
People have their witnesses available July 1st.
We will do our best, Your Honor.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Always a pleasure. Have a great day.
Court calls case People versus James Chandler.
Alexander on behalf of the people, Your Honor.
And good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record?
James Chandler.
Where's the rest of his pants?
I was at work. He was at work, Your Honor.
Really?
And that's and one thing about it is my apology. I had told him it was going to be 2 p.m. And once I seen he was on the 9 a.m. docket, I called him late and he hurried up and
and so what, his pants weren't ready or what?
He probably didn't have any pants.
Oh, I see. Oh. Okay.
But now that
it won't happen again, right?
Never again.
Yeah, okay, go ahead.
Okay, today we're gonna.
So that's not your fault, it's his. Yeah, don't worry about it.
It is.
I know. Everybody knows it's your fault.
I take full
All right.
responsibility. Now, we're just asking for a slight adjournment because the prosecutor needs to check to see if the body cam has audio, Your Honor.
That's correct, Your Honor. Media's been provided, but it's my understanding that Mr. Bird's media doesn't have audio, so I need to check in if there is audio on the videos.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Did you fill out a green form?
I did, Your Honor.
All right, yay.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Philip Brown.
Regardless of people.
Okay, where's Burgess?
He's here.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Philip Brown.
All right, what are we doing?
Your Honor, this was a reissue. I have had discovery for some time, so we were requesting an exam in this matter.
People have witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Barr.
Judge, may I briefly address the issue, bond?
You may.
Thank you, Your Honor. Your Honor, bond is currently set at $250,000 cash surety in this case. Understand the serious nature of the charges, but the allegations are that the complainants in this case ran up into my client's girlfriend's house where he was staying. The police report is somewhat vague on whether the incident occurred outside or inside the residence, but be that as it may, Your Honor, on my client's actions, we do take the position that my client was acting in self-defense of himself, his girlfriend, and her home. And all three witnesses on the case before didn't appear at the last exam, Your Honor, after speaking respectively to their counsel, which they needed appointed because of their potential Fifth Amendment issues. So based on that situation, Your Honor, I think that the bond should be lowered, maybe 50,000, 10%. My client didn't want me to ask for a PR bond. I know the charges are serious, but I do think under the circumstances, the bond's excessive. Thank you, Judge.
Response.
I believe that the bond is appropriate. The report is not vague about where this took place. The allegation is not that these people ran up in the house, it's that they did go to the house, and that this occurred outside, and that a neighbor who was uninvolved witnessed part of this, and it was the reason she was able to witness it is because it happened outside. And so, Your Honor, there's the allegation that he shot at 3 different people in the front yard. As far as the cases, 2 witnesses that were able to be contacted for the exam when this was initially issued did want to move forward. They were not able to come on that date. And so the people were unable to get an adjournment. And that's why there was a dismissal and immediate reissue. It's not that they didn't want to move forward. So, Your Honor, we do believe that this bond is appropriate.
Who was this case originally before?
Judge Washington? Yes. Judge Washington, I believe, yeah.
But no testimony was heard?
Correct, Your Honor. We've adjourned it a few times for them to
Then
speak to counsel.
I'll leave it before. All right. Anything else?
Yeah, only that the 3 people that came to the house came uninvited, and they were all, this was over a dispute, so they were coming there, obviously.
Were they armed?
Yes, Your Honor.
Your Honor, there was one individual who admitted he had a firearm. However, he is not accused of trying to shoot him.
Only accused of bringing a gun to a stranger's house without permission. Yeah. I believe there was an AR-15, Your Honor. That's a semi-automatic rifle.
I have a firearm.
But there are 3 felony firearm charges here at the 3 in possession of the allegations that he's a prohibited person, so he shouldn't have a firearm or ammunition. And then I have 1, 2, 3 counts of assault with intent to murder and assault with intent to do great bodily harm less than murder and carrying concealed. All right. Anything else from either side?
Your Honor, there was one minor. There was a no contact issue to his girlfriend, Latrice Hargrove, when he was rearraigned on this case. That had been lifted last time. There was a confusion as to that. She's just his girlfriend, not a
not a complaining witness to the case. I just asked that he be allowed to have contact with her. She'd be a defense witness in this case.
Any response to the no contact?
Your Honor, she is a witness in this case. I believe that the no contact was issued because part of the conflict is supposed to have been based on allegation that Mr. Brown had done something to her daughter, but I will leave that discussion.
Okay, I'm not going to change the no contact. I'm going to leave that where it is at this point. I'm also going to deny the defendant's motion for a bond reduction. Bond will continue. Thank you.
So if you need another copy, so.
Okay, it does call the case of people versus Leor Mcuan.
Yeah.
Okay. Erica Ozan. I'm the last to know. 25C055, Sarah Wadby. I also call the name of one. Sarah Wadby, please. Where's Sarah? Is that you? Come on. Your attorney says you're not here. You appear to be here. So it's not. It's a mirage. I think she's here. Come on. Unless you want to make a speech. Okay. Wow. You were Sarah Wadby, the 25C055? Okay. This is an initial appearance. You were charged with a state jail felony of theft. And it carries with it, if convicted, no less than 180 days up to 2 years in state jail and a fine up to $10,000. And so it's serious. Got to deal with it responsibly. Mr. Boozler is your attorney. Well, what are we going to do today?
I've never met her before today, so if you'll
I'll need to talk.
hold the announcement, let me visit with her, see if we can dispose of it.
What is your address? Because this shows you are a transient. Is that right?
I came from Ascension Parish. Louisiana, I got transferred here, but I live on.
You were transferred, are you working somewhere?
I clean houses right now.
Yes, ma'am. Okay. So.
It's probably some Ashland.
Excellent. And is it? Just a second. I think they haven't had one, don't they? What's it? What's it?
7763032.
If you know, can you figure it out for me and get it?
Yeah.
What can? What's that, Jeff? You know, how many zip codes are in Orange, Texas?
Just
there's two.
In Mauriceville, this is it.
77630.
307663.
Thanks.
Thank you.
Thank you for being a friend of the court.
Yeah.
Oh, yeah.
Handy. All right. Yeah, talk to her and let me know where we're gonna go next, okay? Ronald Cameron. Yes. On Mr. Cameron, 25CR511, it's an initial appearance. Are you probably intimately aware that you're charged with the third-degree felony of operating a motor vehicle while intoxicated? And it's a felony because I'm showing you have at least 3 prior DWI convictions dating back to 2006 out of Harris County, and Chambers County, those 3. So every DWI that you pick up is a felony. So it carries with it up to 10 years in prison. And are you driving a vehicle? Okay, because you can't operate one without an interlock device. Okay, somebody drives you? Okay.
Yes.
Okay. Yeah, it's initial appearance.
Yes, Judge. He has called out his new affidavit of indigency, but I do not have access to his discovery yet. If I can have a Google recess, he did my hands on the paper and the media associated with this case.
And she's going to talk with you before you leave and get some information from you and make sure that you are forthright. And then we're going to reset this for an announcement in 4 weeks. Okay, thank you. Joanna Glover, please. No answer in the courtroom. I asked the bailiff to call into the hall, please, for Joanna Glover in 25 C 453. No response to the name being called here in the courtroom. No response to the name being called out in the hall. The defendant has failed to appear. Warrant shall be issued for her arrest and bond in the amount of unauthorized use of some bond. Bond in the amount of $10,000 plus she must have a interlock, a GPS device, so we know where she is. She's not in court when she's supposed to be. Julio Ramirez, court report. 24 CR 1277. You, Mr. Ramirez?
Yes, sir.
Okay, this one is an initial appearance. You charged here in clause number 24 CR 1277 with the third degree felon failing to comply with sex offender registration. So that carries with it up to 10 years in prison if convicted. Serious, fix it. She's going to help you guide your way through this minefield.
It's my first time interacting with him, Judge, and I do not have any of the portal or the evidence. So if you give me, I realize it's older, but I do not have any interaction with it yet. So if you'll give me a 4-week reset to get those things.
Okay, does he know how to contact you? You know how to contact him? So
yes.
We're not meeting for the first time when we're supposed to be in court, or because we're not getting anything accomplished here.
Well, just an initial appearance.
I understand. I just want to, but you've not talked to her before to see.
I don't have any way of contacting them
Well,
until I meet them.
did you know she was going to be appointed to represent you?
Yes, sir.
Okay. All right. 4 weeks.
Yes, sir.
Get a replanning. Andre Guillory.
Thank you, Judge.
And this is 22-40681. And Mr. Guillory, that's you. You have to speak out so you can hear. You are charged here with a 3rd-degree felony of theft, so that carries with it up to 10 years in prison. And yes, so what are we going to do today?
He retained me yesterday afternoon.
Very good.
So
announcement.
it's just, yes.
In 4 weeks. No announcement. We said in 4 weeks or earlier, so whatever direction y'all want to go in.
Direction be later.
So just you'll meet with him here in a minute and he'll go over some things with you, and that he'll be your attorney. And I'd follow his advice because he's a smart guy.
Thank you.
Okay. Please give us some things. And listen, we have Ray Wise. Mr. Wise.
Yeah.
25 CR 29. That's you?
Yes, sir.
Okay. So you probably know you're charged with this indictment with a state jail felony of theft. It carries with it up to 2 years in the state jail. Do you have a lawyer?
No.
Yeah, they come in handy when you're charged with a criminal case.
Right.
Are you able to hire somebody?
No, sir.
Why not?
See the money.
Yeah, well, I mean, you're not working anywhere at all?
I own a business, yes, sir.
You own a business?
Yes, sir.
How's it doing?
Not very well.
Okay.
That's what this is from. That's a bill from a vendor that's not paid.
What kind of business is it?
Automotive repair shop.
They still make vehicles out there, don't they?
Yeah.
That's the way people get around?
Yeah, it's just I started.
Where is this, in Beaumont?
No, sir, it's in Beaumont.
It's in Beaumont?
Yes, sir. I live in Beaumont.
You live in Beaumont?
Yes, sir.
All right. You're going to need to fill out an indigent form. I'll sit right over there, fill it out, and then I will review it.
Okay.
If you're unable to hire a lawyer, someone will be appointed to represent you, but the taxpayers are paying for indigent defense. And I'm kind of sensitive about taxpayers since I'm one as well.
Right.
I mean, I got to pay my way. Everybody's got to fix problems when they have a problem.
Yes, sir.
By
And I mean,
sometimes it costs You seem like you understand that. So
I reached out, I thought that all the attorneys and made them.
I understand. Yeah. Well, yeah, we're talking about up to 2 years in the state jail. How much is that worth to you? Yeah, they come in handy.
Yes.
Lawyers, then you got to charge criminal for you. But this, whatever this cost is, I'm going to expect it to be paid back to the county somehow.
Right.
So, you got to figure out how to get those cars repaired. And after yesterday, you ought to have a big old long line of people trying to fix flooding and issues and things like that.
Yes, we do.
Anyway, he just needs some indigent. You see that right there? He's just sit right there in the jury box, fill that out. Let me know when you're through. Thank you, sir.
Well, this is Wednesday stuff. Yeah, that's great. Not you. He's got money down.
Okay, we're going to. Okay, all right, we'll deal with her. And just have a seat. Thank you. We're going to go into this 9:30 docket here. I'm going to start off with Logan Birdsong. Logan Birdsong. I need some files out of that one.
Judge.
On 24 CR 341. This is you are Logan Birdsong here with Mr. Walker, your attorney on the state's attorney. This is an announcement. What are we going to do today?
We're looking at it.
Okay.
It's a difficult place.
Yeah. It's this one. It's obviously this one didn't just get resolved in a minute.
We're gonna have one more final meeting and talk it out, and if we can't resolve it, then we'll put it in the trial docket.
Okay. How much time?
I'm happy to be at the bottom.
Please.
I did. I was.
You can expect him to be there.
There if you're there,
what? How much time do we need? Is 3 weeks going to be enough? You're going to have that done.
Every weekend. Yeah.
3 or 4.
Let's do 4 just in case. Make sure it's scheduled because I know his schedule.
That's not the day.
He's going to reset it. Thank you. Gerardo Galvan.
Yeah.
Mr. Gal, the next one. You lost your client?
I didn't lose.
Just in a few minutes?
He hasn't felt me.
Gerardo Galvin. Was that you, sir? Coming in, that man right there.
Might be.
Yeah, that may be a good question.
Mr. Galvin? Oh, he's here. It's not you, sir.
No.
Gerardo Galvin? You lost your client. Just a few minutes. He was here.
He hasn't found me. Sitting at the passport with us.
This one is
This is one of the delay in this case has been, we've been patiently waiting, as the state has been patiently waiting on any urine test results which we have received, and I'll let you go from there.
And Mr. Walker and I have talked about this case. I still need to meet with the victim and talk to her after getting the toxicology results.
Okay. Going on 2 years.
Yes, I'm aware, Your Honor. We just got the toxicology back right after the last resetting.
That's what, Judge, we've been waiting and they.
So, what is our resetting? 4 weeks? You got all to do on this? Yeah. Seems, okay, reset 4 weeks, please. Thank you. And that's on another announcement. Mr. Walker, will that be an announcement? Is that what we want to call it?
Yes, sir.
Okay. Yes, sir. Okay. We'd like him to be disposed one way or the other. Christopher Kippy. Chris Kippy. Okay, Mr. Kippy here, you've got this first amended motion to revoke now. That's been filed. I guess that's the most recent in April.
Yes, sir. And Judge, I will tell you, I've visited with the state. This case will be resolved. I'm working with Galveston. That's the court notice on 2 new cases. One DWI with a child passenger, the other was possession of a firearm by a public.
With this defendant?
Yes, sir. Yes, sir. And we had a bond hearing, Judge.
Okay, he's got a case in Galveston County.
He's got 2 cases on.
What do we do in this one?
Well, I will tell the court that it's going to be up to what I would like to be able to do. I've got an offer in the case. Give me time. I'm set July the 3rd back in Galveston. What I would like to be able to do is work it out. And take it with 16 with work out with the state. That's all.
So today then, today's June 17th, 4 weeks?
Yes, sir.
Is that puts it in a good spot for resolvement?
Yeah, and Judge, I'm fairly anticipated on the.
Yes, sir. Okay. Yeah, it's not several grounds there that,
I think.
9.
Yeah.
And there's not. Have we received any more reports about, from the SLAM device? Because we got that alert in March. And we hadn't had a problem since then, right? No, you're no problem since then.
The first day.
Because that would be catastrophic. Yeah.
Yeah.
First one, shame on you. The second one, shame on me. And, all right. Okay, 4 weeks now. Here, good to be said. And Lan Kirk. Lan Kirk, Mr. Walker's.
How fits? I'm gonna give you a copy of that.
Lan Kirk, please. Lan Kirk. Okay. I'm doing that today.
Okay, do you want to just hold on it real quick and talk to her? What you reckon? Like, I don't have a, whatever she can pay. What I guess whatever the restitution is. That's what I mean. I mean, it's realistic for her.
I think what we can do is go to, if I don't really, if it's restored, quickly send back, but I don't know what who's getting just.
So Judge, here's the situation. We have an agreement as to the type of plea, most likely, but what we have a disagreement of is of the amount of restitution. And so we're both in agreement that we're going to set a hearing for the restitution determination in front of the court.
Okay.
However, what he's saying right now is that the amount of restitution would affect, from their perspective, how much time they would ask for the length of probation. Because there's some amount that I guess if it were lower, that she would be able to pay in a certain amount of time, and there's some amount that if it were higher, she'd be able to pay in a lengthier amount of time. And so what he's suggesting right now is that it would be an unagreed plea in front of the judge, and then we would reset it for a PSI and a hearing on the restitution.
Generally on, you know, I know other judges did the same thing. And learned from other judges, but on that's the victims being repaid and put back whole. That's our foremost concern. The quicker people do that, the quicker the reward. There's, what's the point if it's paid back timely and other key items like theft class, things like that are completed? Why hold it open for years when the way it's fixed is you can pay the people back. Now, if you hurt somebody, like you break an arm, you can't unbreak the arm. You can repair it. It's like money loss is fixable, but the quicker you do it, the more you get rewarded. The people who are out the money, the longer they're out the money, they're out that interest and use of the money. You don't pay interest back. The federal government does. When I was with the federal government in the U.S. Attorney's Office, people had to pay interest on the loss, like a loan, which is more fair to the victim. But we don't do that in the state. So I push getting it paid back, because if it takes a year, they've lost that money and use of the money for a year. So they're still out. Paying the money back as soon as possible is what gets the reward. And that's why I push forward, because it's less harm to the victim, because they're always harmed. They'll always be out something on quid pro quo paid because you don't pay interest on it. Yes. What's the amount for loss we're talking?
Well,
is that still in debate?
Yes. That part, and I've had such a difficult.
Well, I'm the arbiter.
Right. So when we've got records, I'll bring the complainants and we can have a hearing, and it should be fairly easy to kind of sort through and determine.
It's a huge judge.
Right. I think on the low end, it's closer to 25,000, and on the high end, it's over 100,000.
Which is what we make the say so 150.
It's like 30 to 150.
Yes, sir. And so I can tell you this less. So I want to make sure, that's what I was just telling Mr. Greco. I want to make certain that however I proceed with it, that I don't want to compromise or.
Well, if it's less than 30, then but it's still, it would be a state jail felony.
Correct. And that's maybe the thing to do, Your Honor, and I'm going to need just a little time to talk to Ms. Burke about it. Maybe the thing to do is to do an agreed plea of a felony where I think reserved in life.
So essentially, you'd be stipulating to the other elements besides the amount of loss. Essentially, you'd be stipulating to the other elements besides the amount of loss.
Yeah, and that's what I want to make sure that I.
Right. Either way, I think we've figured out a way where it would come before you.
What do we want to do?
If it's a hearing where I need to prove up, have witnesses available for the restitution amounts, 4 weeks, I think is what we were thinking about. Or somewhere in that range.
You're the 4 week man now, because you'll be doing a lot on that day, but that's okay. If you can keep it, I mean, we can take care of a lot of business for you.
Couple of days to.
No, I think I could do everything in 1 day or less.
Judge, I can have 6 weeks. So
Okay, we've got it done. All right, reset it for the end, 6 weeks, okay? Thank you.
Thank you, Judge.
Let's get a reset and thanks. Langston, Adams?
I'll sign it right now.
I've got Daquan Hadnot and Xavier Ingham and Brendan Mingo, Arius Wilson, to name a few. Let me know when you're ready.
We do have a plea from the initial this morning.
Go ahead.
Mr.
Mr. Dusler?
Yes.
You got a plea, and who is it?
Sarah Logan.
It's from the initial judge.
Okay.
You should know how to file.
Sarah Wadby, please come forward. 25 CR 55 is now called. The state of Texas versus Sarah Watkins. Who is here with Mr. Dudesler, her attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in a summary fashion?
Yes, sir.
In summary, this indictment alleges that on or about June 24th, 2024, about a year now, that in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached where you would be pleading guilty, sentenced to 2 years in state jail. That would be suspended. You would be placed on regular probation for 5 years in order to pay restitution. It looks like it's in the amount of $18,592 to the complainant in the indictment in this case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, ma'am, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into without objection and submitted. Among other things, this states you are mentally competent to enter your guilty plea, and it's freely and voluntarily made. You know what you've been charged with, and the indictment's been read to you, you've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer, all true.
Yes.
So help you God. State's Exhibit 1 is made a part of the record without objection. Pre-sentence report is ready?
Yes, sir.
I am going to follow this agreement, and if nothing further, I'm going to make the findings that you are mentally competent to enter your guilty plea. You're pleading guilty here today,
Yes, sir.
voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea by State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You hereby sentenced. You confinement in the state jail for 2 years. That is suspended. You were placed on regular probation for 5 years. There will be terms and conditions of probation which are normal and customary for this type of offense. Among other terms of probation, you must pay restitution in the amount of $18,592 to the complainant in this case, whose name is listed in this indictment. How are you going to pay this back? That's a significant amount.
I have family help. That will be.
Quicker,
Yeah.
quicker you pay it back, quicker this ends.
Yeah.
But it won't end until you pay it all back. Because victims have to get paid back,
Yeah.
fixed, back together. And that's your responsibility. But this can last as long as 5 months or longer, 5 years or longer. If you can't pay it in 5 years, what we'll do is we have a motion to revoke probation filed so we can continue the probation term, and it can last. Okay, well, we'll see. Quicker the better. And that will, all other things being good, then it can be terminated.
Hopefully the guy that's working me.
Ma'am?
Hopefully the person that's working me did it.
She's gonna work on trying to get the vehicle.
What was it?
It was a U-Haul truck. So she's gonna try to locate that, which will reduce the restitution.
Good. You've been, let's see. Okay, Please see the probation officer. Thank you. That's not big. Charlize Berwick?
Yes, ready for it.
Come on up. Is it into attempted? 25 CR 313 is now called the state of Texas versus Charlize Elizabeth Berwick. Am I pronouncing your first name?
Yes, sir.
You're here with Mr. Lane, your attorney and the state's attorney does the defendant's reading of the indictment and arraignment here. Can we proceed in summary?
She did.
This is on the,
In summary, this indictment alleges that on or about December 31st, 2024 in Jefferson County, Texas, you committed a state jail felony of burglary of a building. Do you understand what you were charged with here? An agreement has been reached between the parties that you will be pleading guilty to a lesser included Class A misdemeanor of attempted burglary of a building, which would carry with it up to 1 year in the county jail and or a fine not to exceed $4,000. Kind of ran out of room there.
Sorry.
Was an art major. Say that again. You were an art major? The lights must have been off at the buildings a lot.
Abstract.
Okay. The agreement has been reached here, man, where you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length. There will be terms and conditions of probation, which are normal and customary for this. Right. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Understand?
Understand.
How do you plead to this lesser included Class A misdemeanor of attempted burglary of a building, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you. What's marked as State's Exhibit 1? Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Right.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection committed. Among other things, the state you were mentally competent to enter your guilty plea that's freely and voluntarily made. You know what you've been charged with. In fact, it's been read to you. You've read it. You were guilty of the crime charged, and most importantly, what it says here, and any lesser included offenses, which what you have pleaded guilty to, and what you will be sentenced for. The attempted burglary of a building. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfying with the representation provided by your lawyer. All true, so help you God. Correct.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
It's waived, Your Honor.
I'm going to follow this agreement if nothing further and find you are pleading guilty to this attempted burglary of a building, the lesser included Class A misdemeanor under this indictment. You are doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1. You admitted to finding guilty beyond a reasonable doubt. And I am going to instead defer any finding of guilt, place you on deferred or unadjudicated probation for 2 years. There is no fine. Correct. Is there restitution?
No, sir.
There will be terms and conditions of probation, which are normal and customary for this type of office. Make sure you follow them. If you fail, your probation could be revoked. You could be sentenced to county jail up to 1 year. Okay. Be careful. And here's the probation orders. Thank you very much. Thank you. Anything?
No, Your Honor, thank you.
Thank you, Mr. Long.
Over here.
Don Newsler?
Yes, sir.
Heaven Johnson.
I've called the name, no response.
Heaven Johnson? Is that you, ma'am? There she is.
I've never met her.
Oh, there's there's your lawyer. You've never met. God bless you. Is that the best you can do? Wear to court? Here, did you wear that to church?
No.
I know we're not church, but it's a place of honor, and this is part of the Constitution and all. You're not, try not to wear a billboard sign to court. You know, something. Just look around. Look what everybody's wearing. See, it looks nice. It's kind of honor, dignified. Do better. Talk to I have to tell people how to dress.
I'm pleased with it.
And Mr. Adams, we're going to put you at the very end today because
It's good pleasure to meet you. That means all the
Daquan had not.
I sent it to you. You got it.
All right.
I'm fingerprinting right now, sir.
That's Mr. Hedman.
That's Mr. Headline. That's done.
Go see him. I'm working.
We now call cause number 24 CR 2253, the state of Texas versus Daquan Hadnot. That's you?
Yes, sir.
Present. Mr. Adams, your attorney, your state's attorney, does the defendant waive the formal reading of the indictment and arraignment here. Can we proceed in a summary, Pat?
Yes, sir.
In summary, this indictment alleges that on or about August 25th, 2024 in Jefferson County, Texas, you committed the state jail felony of theft of. Do you understand what you're charged with?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be guilty and placed on deferred or unadjudicated probation, which can be up to 5 years in length. And it looks like another case is going to be dismissed. Is that on my docket?
No, it's a misdemeanor case, Your Honor.
It's a misdemeanor. And then there will be terms and conditions of probation, which are normal and customary, plus you have agreed to forfeit the weapon to the state of Texas. Is that right?
Yes.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Also, you're going to, did I say $500 fine? Yeah.
Yes.
$500 fine involved here too. How do you plead to this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? You
Yes, sir.
understand it? Discuss it with your attorney or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
Without objection admitted. The state you are mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged. And you're giving up your right to your jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfies you with the representation provided by your lawyer. All of this is true. State shall help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes without objection.
No objection.
It is so done. Pre-sentence report waived.
Yes, sir.
I'm going to make the following findings. You, sir, are pleading guilty today voluntarily, and you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked. You can be found guilty and sentenced up to 2 years in the state jail. You must pay a fine of $500. Also, you shall be ordered to forfeit the firearm, which is
It was a different firearm, Your Honor. It was, he's talking about the misdemeanor firearm.
okay. Can you
This firearm didn't,
identify it? Do you know what it is? Because it just says a firearm. It's just, there's nothing to identify specifically what we're talking about. I see.
Let me look. I can probably find out for you.
Okay.
So, yeah, you quick answers to that.
Hold on. I then detained Hadnot to retrieve the panic handgun from his waistband, at which time he informed me of an additional handgun, a 6 Sauer, also in the waistband.
I got on both participants. Look, Judge. That gives you the serial number on both.
I know, but which one is the one that he's forfeited?
he should forfeit both. One of them was stolen, so he doesn't have any right to it. And that one, I believe, is the 6 Sauer.
So that's for both of us. With the serial number.
What do we put in there? What do we put in the probation order? He's going to forfeit which one, and he's forfeiting one and returning the other to the rightful owner. Is that right?
He don't have either one. No, he don't have either one. So really, they both
will be forfeited
Yes, Your
and
Honor.
returned to the rightful owner.
Okay, they're going to be forfeited to the state and is a Here.
And then return to whoever was the actual owner.
Okay, it's a Canik TP9 9mm firearm and a Sig Sauer 9mm firearm. And we'll give this to the probation officer so she can identify, have it identified in the probation order. Anything else?
That's it.
All right. Thank you. Please see the probation officer.
All right. Mr. Xavier Ingram, he's a plea as well. Sir. Probation officer.
Xavier Ingram is now called in 24 CR 2387.
Come up, Mr. Ingram.
That's you?
Yes, sir.
I need Mr.
Okay, sorry.
You know, I don't memorize these. I gotta have these still.
Yeah, do nothing.
24 CR 2387 is called Xavier Ingram.
Yes, sir.
That's you? With Mr. Adams, your attorney and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on about October 1st, Halloween night here, 2024, in Jefferson County, Texas, you committed a second-degree felony of bribery. And you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years in prison or less than 2 years in prison. In addition, you're going to be assessed a fine up to $10,000. Do you understand? Yes, sir. Agreement has been reached in your case that you would be pleading guilty, placed on deferred or unadjudicated probation up to 10 years in length. There will be terms and conditions of probation, which are normal and customary. Is there any loss of money here or something?
No, sir.
Okay. This says Jefferson County JCDI. Tell me out. What's
That's the
I know what that is, but why is it in here?
If you look at the PC, Judge, it's very clear there's a drug issue here that's underlying this offense.
But the probation office is going to take care of this today, but they're going to do a kind of a post-sentence investigation to determine what issues we may need to address in addition to this to prevent further criminality and for you to do better. So there may be additional terms and conditions other than what we're going to be setting forth here. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes. I'll show you here what's marked as State's Exhibit 1. Did you sign that document? Thanks, Langston. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are incorrect? Yes. State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, the state you are mentally competent to enter this guilty plea is freely and voluntarily made. You know what you've been charged with. That seems like you've read it. You're guilty of the crime charged in any lesser included offenses. You are giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by your lawyer. All true, so help you God. State's Exhibit 1 made a part of the record. For all purposes, pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir. Nothing further and find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to instead defer any findings of guilt, place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it will be shortened to 1/3. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, you shall be ordered to attend and successfully complete the Jefferson County Drug Intervention Program that will be supervised by the probation office. Make sure you follow these requirements. If you fail, your probation could be revoked, you could be found guilty, and you could be sentenced up to 20 years in prison. Do you understand? Fix this mess. There you go. Thank you so much. Please see the probation officer.
Thank you, Judge.
My God, you're going to go on and go some speak to it. When you make this, you. I don't still there.
Kevin Johnson, you said?
No, this is, sorry.
This last two.
Okay, here's this phone. And Brandon, Mingo. You were charged here in this indictment 25 CR 18 with a 3rd-degree felony of evading arrest or detention with a motor vehicle. Mr. Adams is your attorney. What today?
Judge, I think it's back I explained, but the initial offer was great probation. I understand the state can no longer do that at all. But it had to do with Larry, but the policy
Has to do with the circumstances of the offense, because the officer was injured in the wreck.
So what happened was the initial offer was for straight probation. He was going to accept it, but now I know the officer being injured, got the office in Capital 5. So he's telling me now that he's going to hire his own lawyer for the next appearance. Is that right? Can you tell me he's going to hire your own?
Who?
I have no idea.
Yeah, I'm asking you, who you're hiring?
I'm not hiring. It's my family lawyer.
Oh, okay. So your family's going to hire somebody to help you.
Yeah.
When that happened?
He said you're going to be here the next court date.
Okay. Until such time. There's a big sign that says don't bring the phones in. I know everybody's got one, but when it's on and I can see it, then you can be held in contempt of court, and we can also take the phone and give it to the Humane Society. Let them use it. Don't misuse the phones. Don't record in here, or else that'll put you in jail. Go ahead, what else?
So, like I said, I mean, he said no to the cap, and now, like I said,
Okay. So what are we going to do?
He said he going to hire a lawyer. So I was.
Is that right? Okay. How much time do you need? You say 4 weeks, maybe?
I said the next court date.
4 weeks. Good. All right. I'm going to reset it for 4 weeks. He's still your lawyer until such time you get a replacement. Okay. Here we go. Get a reset. Thanks.
And then my last one is Wilson and Tuesday.
Aries.
Understand.
I don't know how I did that one.
Wilson, please come forward. 24 CR 2123. Okay. Professional bail bonding was still taking care of your bonding? Yes. Okay. Because there was an issue before if you were somewhere else. Now you're no longer there.
Yes, sir.
And, okay. You were charged here with the state jail felony of theft, and which the state's in the indictment that occurred on or about August 14th, 2024. Was this the one, who's on this? Was the state going to re-indict this? Is this one y'all? Who is this? On Arias Wilson? Who's the prosecutor on that? Okay. Because you have an enormous amount of theft convictions, 8 we count here. Every time you steal a pack of gum, it's a felony. You understand? I mean, if it's a pack, it's going to be a felony. Every time, the rest of your life. But also the way this, these convictions out of the 252nd District Court and in 2016 and a 2023 conviction out of Fort Bend District Court. I don't know if the state's intending, we had something come up the other day where we had a group of these and it was a state jail felony, but the state intended to enhance the punishment because of the prior felony convictions that were in sequence. I don't know if this was the case or it was one similar to this. But is there a plan to enhance the punishment?
It was not my plan at this moment, Your Honor, to enhance the punishment.
Okay. It is enhanceable though, right? Is that?
I believe so.
Okay. Which if it was if that last one is in sequence to the 2016 cases, you could be looking at up to 20 years in prison as a potential. If it's not in sequence, then 2 or more felony convictions can boost this to a 3rd degree punishment range, but it's still a state jail felony technically, but the punishment range could be higher because of those 3 prior felonies. So y'all need to look into that and see where we stand today. What are we going to do?
The current offer in this case is 2 years straight probation. I'm sorry. Yeah, 5 years straight probation with 624 restitution.
As it's just a flat state jail felony?
That'd be a flat.
Okay. So y'all signing up or not?
So do you still want to call? Or you still want to call?
Okay, that's okay. Great. It'll be set for trial. And
I really
real estate, I don't, you can hire anybody you want.
Okay, I didn't know.
You can hire anybody you want. He's appointed to represent you. You don't get you get a competent lawyer, that's him. You can hire anybody you want. But if you're able to hire somebody, why are you telling me you needed an appointment? Because the taxpayer shouldn't be paying for your mess. You're supposed to pay for it, like I should do when I make a mess. You understand? The taxpayers aren't going to foot the bill if you're able to hire somebody. But if you're able to hire somebody, tell me immediately, because we're not going to be continuing to pay your way. Do you understand?
Yes, sir.
It's what 250,000 people tell me all the time. They don't appreciate that. So pay your way. But I want the state to look into whether we're looking at 20 years in prison or just 2 years. Okay. And we'll set for trial. Okay, we'll set for trial. Thank you. That's all. Get the trial setting. I have, is Mr. Jeffries here?
Same judge. I'm gonna play judge.
That's your topic.
Sir, what is your name?
I'm here for Justin Coleman.
Okay, I don't see your name on the. Yes. Say that again.
Dustin Coleman.
Okay, there you go.
I'm here for a reset if we just want to call him up real quick. Thank you, Judge.
24 CR 1887.
I appreciate it.
Yeah, welcome.
I haven't been in court.
Tell me where.
I'm from Austin.
Austin.
Yes, sir.
Okay. You see any rain yesterday?
I did. Yes.
Could use it, huh?
Yeah.
Okay, you are Dustin Coleman. I need Mr. Coleman's file, please.
I've discussed this with the state. We're going to reset this. Good. Just reset this for 30 days for a plea.
Okay. As you know, sir, you're charged with the state jail felony criminal mischief, which carries with it up to 2 years. You know, it can carry with it up to 2 years in the state jail. And it's serious. It's important. And Mr. Comerville here seems like a competent man. So I heed his advice, and he's your lifeguard. He's going to save you from the deep end of the pool here. How much time?
30 days.
You got it? 4 weeks? 4 weeks?
That works.
We'll say it for 4 weeks. Please get a resetting. Thank you.
Thank you, Judge.
Yes, sir. I've got Kevin Johnson.
Ready, Your Honor.
Come on up. Kevin. I'm sorry, Johnson, please. Thank you. Thank you. 24 CR 1671 is called. You were Ms. Johnson.
Yes, sir.
Yeah. Present with Mr. Dusel, your attorney, and the state's attorney does the defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes.
In summary, this states that on or about July 5th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
Agreement's been reached. You will be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, and fined $500. Is that your, and there will be terms and conditions of probation normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
All right. I'm showing you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are correct?
Yes, sir.
State's Exhibit 1 tendered?
No objection.
Into evidence without objection. It's admitted. This states you are mentally competent to enter this guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're giving up your rights to a jury trial, the rights to the appearance, that's examination, confrontation of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. State so help you God. Correct.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is out. I'm going to follow this agreement, ma'am, and find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. We can shorten it to 1/3 of that, 3 1/3 if you do well. And there will be a fine of $500. Other terms and conditions of probation, which are normal and customary to this type of offense. And I'm going to sign this, and you'll meet with the probation office and begin probation. Good luck on this.
Mr. Moore, proposing this morning, very afraid of coming out the position.
Okay.
Like, yeah.
Sophia Martin.
We're at this table, Judge. That's Mr. Jeffrey's case, Judge, and I'm with him today.
Oh,
She is present.
I need. Sophie,
There's all the things.
and Martin. That's you? Yes. Thank you very much. And, your attorney is, Mr. Jeffries. But, this nice lady is standing in for you today. And what are we going to do today?
Yes, Judge.
Judge, I've been talking with Mr. Jeffries about this case, but I have not yet made an offer. They're waiting on me, and I'm still looking into a few things before I do so. It's my understanding she's at a different school district now and doing fine there. Okay.
I didn't hear that.
I do believe they've submitted an application for pretrial diversion. I don't know if that's been objected or.
Okay, what are you going to do today?
Yeah. Just need more
How
time.
much time?
4 weeks. Judge.
4 weeks reset. Okay, thank you, done. Here's that one. Thank you. What about Jamal Mosley? Are you here for that one?
Yes.
Okay. Jamal Mosley, that's you, Jamal Mosley? And in 2014-1683, you are charged with a third-degree felony of unlawful possession of a firearm by a convicted felon. This carries with it up to 10 years in prison. Are you still on Hackamore? Yes. Okay. Yes.
Mr. Jeffries is requesting a 4-week reset. He has requested the media, but he does not have the media associated with the case yet.
Tell me the next one.
He's been on it for 3 months, but when's that going to go down?
It's been requested by my office, Judge. I'm sorry, I don't have any information.
And I get 4 weeks
Yes.
attention setting.
Thank
Thank you. Give it a second. I have Crystal Bro.
Yes, Judge, she's a plea. Okay, finger.
Crystal Bro, please. Thank you. 2 cases. To both of them or one
Just the
dismissal?
one, Judge. This row, you're gonna come with me. Okay, got it. Quick row, please raise your right hand, please share it over. Put yourself a touch. Okay, and put your right hand print. Place it flat on your box. Can't get up again, it's in, dark and that. Okay, place it right, logo right here.
James, you, Mr. John, what is he?
My judge.
We've got, Mr. Stan, okay. And Mr. Davis, right? Yes, Your Honor. Yeah. Let's do these. What are we going, which one are we going to go on? We have.
I'm about to sign. 0218 is the one I'm going to, Judge.
Okay,
And then there's all 19.
1-9 will do
Yeah,
this.
that's
Great. So we call 25 CR 218, the state of Texas versus Crystal Bro. That you? Yes, sir. With Mr. Now, your attorney and the state's attorney does, and defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yeah.
In summary, this indictment alleges that on or about November 16, 2024 in Jefferson County, Texas, you committed the third-degree felony of injury to a child. And it carries with it no less than 2, no more than 10 years confinement in prison, and a fine of $10,000 can be assessed. Do you understand the punishment range here? The agreement's been reached where you'll be pleading guilty, placed under further unadjudicated probation up to 10 years in length. Fine $500. It will be terms and conditions of probation, which are normally customary for this type of offense. We'll get some. What's the relationship of the child to the defendant?
Sorry.
Daughter? Wow, okay. But there will be, I'm not sure, are y'all estranged? There will be a parenting class, which will be the very least, the other, this one's a new one, unique. Whatever the probation office deems is most appropriate under these special circumstances, so that this choice doesn't happen again is what we're going to want for probation terms. If I follow this agreement, you have no right of appeal of your case. Do you understand? Yes. How do you plead to this charge, guilty or not guilty? Yes. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. show you what Mark State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection admitted. The state you're mentally competent and to enter your guilty plea, fully and voluntarily made, you know what you've been charged with, the indictments and investigating you data. You were guilty of the kind of charges and any left included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, told us satisfied with the representation provided by you. You're all proof, so help you God. State's Exhibit 1 is made a part of the record. Any pre-sentence report, Wayne?
Yes, Judge Blake.
Okay, I'm going to follow this agreement and find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt placed on deferred and adjudicatory probation. For 10 years, you must pay a fine of $500 for other terms and conditions of probation, which are normal and customary for this type of the circumstances of this case. Make sure you follow them. If you fail, probation will be revoked. It could be sentenced up to 2 years in prison. Now, we got 25 CR 219. That shall be dismissed. Thank you. Please see the probation officer. Again, your name, ma'am?
She's one of my initial.
Yeah.
No, this is right here. Just have those files.
Which one? Right here? These two? Oh, man. You were a little late, right? Did you fix all that?
It was down the hall at 143. He wasn't aware. She had
Yeah, well, so you gotta be careful because
She has my office number.
your bond could be revoked, which is what I did. I'm unrevoking it.
Thank
The
you so
bond's
much.
back in place. But it's important what kind of, the bus leaves, if you're not on the bus and then you're running after the bus and you can't catch the bus, it'll outrun you.
Thank you, sir.
So you filled out an affidavit of indigence form here. You had absolutely no income at all?
I'm actually starting a job today, sir.
Oh, okay. What are you going to do?
I'm going to be working as a keeper at Jamestown.
Okay, all right.
It's basically like a.
You have children?
Yes, sir.
Okay. The father of these children, is he helping out at all?
Yes, sir.
Why not? You're looking around like
He's
a bum?
girlfriend.
Man?
He's got a girlfriend. But
Well, he's got children. What a war thought process. I mean, we got our priorities kind of all mixed up there. I guess that's why you're not with it.
that's my house.
But well, okay. Well, shame on him, but I mean, he's, there's talking to an attorney to help you here. There's a way of making people who want to fail on their responsibilities be responsible, because it's costing people money. I mean, these children have to survive, and it costs shelter, food, things like that. And if you're having trouble with your income because he's not paying his responsibilities, the taxpayers shouldn't be paying. Yeah, that needs to get fixed, and he needs to be held accountable. So he can figure that out. That's just, I think on behalf of everyone who's responsible, that makes us angry.
It just makes me sad for the children.
I don't declare you anything. All right, what are we gonna do today?
That's why I'm get access to discovery for media.
It's done. Get a reset.
Thank you so much. Yes, ma'am.
Ray Wise, please come forward. Ray Wise, thank you.
Oh, thank you.
Wait, I've got this. But you got this affidavit of indigence we filled out. Your income is $3,500 a month.
Give or take.
That's a fortune to most people here. That's not indigent. You're gonna have to figure a way to pay to the problem. You're gonna have to pay some lawyers, but I mean, 3,500, that's 42,000 a year. That's not destitute. That's not poor. That's I know everything costs more, but and your expenses are 2,000. You got $1,500 left over, and that's I'm not gonna. The taxpayers aren't gonna pay when you're making 42,000. You're gonna have to go hire a lawyer, okay?
I did call a few lawyers and they were
Expensive?
5,000, 7,000.
Well, you're charged with theft.
Yes, and I have the money to pay for the bill, the $3,000.
Well, that's good. That's good. That might be able to resolve it.
I say I had it, I will have it in 3 weeks.
Ms. Manaldi, would you?
Joanna, please, this honorable court again, Brandon Bird on behalf of Leor Mcuan. Mr. Mcuan, can you please state your full name for the record? Please.
Thank you. All right, what are we doing?
I would really like to get this resolved, Your Honor. But if Sister Prosecutor doesn't believe that we can get this resolved, then we're gonna set this matter for exam.
You have all the discovery.
I do have all the discovery.
People have their witnesses available to first. You need to, sir, you need to hand out.
Oh, I'm sorry.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Just for the record, the offer has been that if Mr. Mcuan could provide proof that he could drug treatment since the date of offense, that would be offered a use, however, that apparently is not.
I say anything? I've been in treatment for 5 years. This case is 5 years old. So is there any way we could adjourn this matter, Your Honor, to provide Sister Prosecutor?
I passed all my drug tests, every one of them.
I need a green sheet. Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Thank you. July 3rd.
Okay, sir. Thank you. Thank you, Your Honor. Thank you for your patience today, too.
Thank you, sir.
What?
Thank you for your patience today.
Oh, no, that's really not in the cards. Thank you. Court does call the case, People versus Todd Rayberg. Now you get it. All three
Morning,
cases.
Your Honor, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Rayberg. And Your Honor, I do have some paperwork here. I just had it. Mr. Rayberg, could you state your name for the court?
Todd Rayberg.
I swear I had it, Your Honor. Here it is. I am requesting a brief adjournment. One of these cases is very new and I didn't have the police report yesterday when I met with Mr. Rayberg. I'm also submitting to the court a proposed release to treatment order if the court would consider signing it.
Any objection to release the treatment from the people?
There's no objection.
I'll sign that order. And then I'll grant the adjournment in this matter. On the 6th, which is going to be the day from where you want the 3rd.
I think probably the 3rd, Your Honor.
Good enough.
Thank you.
So probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will.
Thank you.
Okay. Court does call the case, People versus Adam Barry. This is the one.
Oh, different. No, it's one.
Right. The people put their appearance on the record. Joe Simon, you did, right? Sorry. Joe Simon, on behalf of defendant Mr. Barry, state your name.
Adam Barry. All right. You need an adjournment in this case.
Yes, I'm going to supply some mitigation documents to the people in support of a request.
think July 10th was.
I will be back, Your Honor, but you may be seeing too much of me on that particular day.
Oh, I'm seeing too much of you every day.
So either the 10th or the 17th, but I have, sometimes the court gets mad when he sees too much of me.
July 10th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you.
Or if you want to wait for me.
Court does call the case of the People versus Mohammed Dar.
Say it again. Yeah, actually.
Assistant Public Defender Qasim based on behalf of Mohammed Dar, who is present to my right. Mr. Dar, could you state your full name for the record?
Mohammed Hassan Dar.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, there is no offer, so we'll be requesting to set this for a preliminary exam at the soonest available date.
You have all discovery.
To my knowledge, Your Honor.
People have their witnesses available the first.
Your Honor.
Preliminary examination in person, July 1st, 2025.
Your Honor, may I address bond when
9
appropriate?
a.m. Yes.
Your Honor, my client is requesting a PR bond. He has two jobs on the outside that he would like to keep. This is in a group home. He supports his mother financially by sending her money. He also has some personal matters that he needs to be taking care of on the outside. I don't believe he's a further danger, Your Honor, if the court is inclined to give him a GPS tether or put in the no contact, no go-to orders. He's going to do whatever the court deems necessary, Your Honor.
Anything.
Strong.
I object to any modification of bond at this time. My understanding, Your Honor, is that the defendant was currently on bond at a case out of the 15th District Court, failed to appear at that case while he was hospitalized, which is where this offense took place. In this present matter, the defendant assaulted a nurse by grabbing the right breast, and she was placing a blanket on him. I object to the modification.
Well, we certainly understand how serious the allegations are, Your Honor. As I said, my client is open to any no go-to, no contact orders, anything the court deems appropriate. We don't believe he's a further ongoing danger to the community nor a flight risk, Your Honor, at this time.
His bond is set at this point at $1,000 cash surety. So I think that's appropriate given the allegations in this case. Motion for bond reduction is denied. Bond will continue.
What was that date, Your Honor, for the
July 1st?
Thank you.
Thank you, Your Honor.
July 1st before Judge Barr.
Thank you, Your Honor.
Did I put that in there? I think I did. Double check it. Yeah. Court does call the case People versus David Witherspoon.
Ready, Your Honor. Andrew Bannister.
Your Honor, Joe Simon, on behalf of Mr. Witherspoon, is making his way to the podium. Mr. Witherspoon, state your name, please.
David Witherspoon.
Your Honor, may counsel approach?
Yes.
Thank you, Your Honor.
Please state your name for the record.
Mark Hubbard.
Your Honor, we're respectfully requesting an adjournment. We just received discovery and have yet to go over it with the clock.
Is there anything else holding him or?
I don't believe so, Your Honor. I believe
This is the only thing holding him.
correct.
All right. Probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Court does call the case of the People versus Joel Jones.
Good morning, Your Honor. David Burgess on behalf of Joel Jones, who does not appear to be here.
She's not here.
No.
Got it. Joel Jones, you were just appointed on this case.
Yes, Your Honor. So I don't have a contact number for her at this time.
And well, the reason I'm asking, I think she's been on bench warrant status.
She was, I think I appeared on Zoom on the 20 case, Your Honor. There's 2 cases, I believe.
Right.
Yeah. And I appeared on Zoom that day and I gave her my information, but I did not receive a call from her.
Bench warrant will issue for defendant's failure to appear in each case. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. You can get that one. You can get this one. Court does call the case People versus Tevante Jackson.
Allie Zend on behalf of the people.
I have anybody that left.
I can't see, I'm so sorry.
They're not. They're coming. Tevante Jackson. You have Jackson?
Assistant Public Defender Sandra White on behalf of Tevante Jackson.
State your name, sir.
How you doing, Tevante Jackson?
What are we doing?
Your Honor, we're asking for an adjournment in this matter. Apparently, there are some jail calls I was just made aware of that we need to review.
Your Honor, I'd like to address that.
All right. I'm gonna need a green sheet. All right, yes, Esteban.
Thank you, Your Honor. It's come to my attention, this defense has made 16 complete calls to the victim this week, as well as 142 attempts to call her. All their extremely concerns of the calls. The victim tells him she wants him to stop contacting her, that she's gonna come to court. He continues to keep calling her, as well as having a third party reach out to her. He says to the third party, "You want to do me a solid?" Third party says, "What's that?" He says, "Pull up on that bitch. She's gonna cry to you. She's gonna do all this crime shit to you. Just pull up on her for me and be like, yo, don't cook." Because yesterday I talked to her and she kept going on about testifying. So I have extreme concerns that he's not only reaching out to the victim, but also third parties to contact the victim on his behalf. And would ask his phone privileges be revoked.
Any response to that?
Yes, Your Honor. I would ask, first of all, we need to review these calls, but that the phone privileges only be revoked to that certain number. Mr. Jackson needs to call his parole officer, so we are asking for the calls to only be revoked to that certain number.
You need to do what?
Calls, have phone calls with his parole officer. We are trying to arrange certain things.
But the calls that the people are talking about aren't parole calls to his parole officer.
That is correct, Your Honor.
Probable cause conference will be adjourned to July 3rd, 2025, 9 a.m. At this time, pending a hearing or request for a hearing, defendants' phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Bond will continue. That was for you. Court calls the case, People versus Joseph Bailey.
Allie Zend on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bailey. Could you state your name, Mr. Bailey?
Joseph Bailey.
You forgot his pants too?
Oh, Mr. Bailey, you gotta wear long pants in court moving forward. Your Honor.
Pardon me about that.
Pardon?
Said pardon me about that.
Okay.
We're asking the court to set this matter for preliminary examination. And my client does have a request relative to his bond conditions.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 1st, 2025, 9 a.m. before Judge Perry. Esteban.
Thank you, Your Honor. Mr. Bailey is currently on a hot zone tether. He's asking the court to consider removing that requirement. He is a moving truck driver. He's a soccer coach. And my understanding is that this case involves allegations of electronic communications only. So, Your Honor, I believe the no go to and no contact order are sufficient.
But it's an aggravated stalking that may begin with electronic communication.
Understood, Your Honor. I just wanted to make the request.
Response.
Your Honor, I object to any bond. This is an aggravated stalking when she violated a people. I have concerns about the victim and would ask that the tether remain on, given we already violated a court order to initiate this case.
Well, okay. Motion for bond reduction or bond modification is denied. Bond will continue with its conditions. All right, thank you.
Thank you.
Thank you, Your Honor.
I have some. Court does call the case People versus Chad Jones.
And Laura Yagi, Assistant Public Defender, with me on behalf of Mr. Jones, who's approaching. Mr. Jones, could you state your name for the court?
Chad Jones.
And Your Honor, I did submit, or I did fill out, not submit yet, but a green sheet. Mr. Jones is seeking a global resolution. I am asking for another adjournment. We need some paperwork from some other jurisdictions, but I am asking for a 2-week adjournment for
2 weeks. You'll be able to get to everything you think in 2 weeks.
I'm not sure, but I think it makes sense to just ask for 2 weeks at this point.
Any objection?
There's no objection. Your Honor.
Probable cause conference. So, well, I have 10 days out, but you want July 3rd date?
To the preference. Okay, that's fine, Your Honor.
All right. July 3rd, 2025, 9 a.m. Bond will continue. Court calls case of People versus Grace Brenner.
Allie, then on behalf of the people.
Assistant Public Defender Sandra White on behalf of Grace Brenner. Your Honor, I have tried to contact Ms. Brenner. She works through a worker and the phone number, I think with Avalon Housing, I'm not sure. I don't believe she's missed any court dates, so I would ask for an adjournment.
Your Honor, at this time, I wouldn't object to the adjournment. Ms. Brenner normally appears on Zoom, and Ms. Apple is normally covering her case, so there may have been a slight with Ms. Apple being this week.
Really?
I believe so, Your Honor. She has been at every previous court date.
And I thank Ms. Zenda. We did talk about that, and she said we did.
You two?
And we're hoping
you
that-
two rigged this whole thing for an adjournment?
Yes, and we're hoping you agree.
And Allie signed on?
Yes, she's nice. Sometimes.
Oh. That implies
Sometimes.
that implies others aren't. Who are you talking about?
We're not going to mention any names.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. without objection. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Paris Lester.
Good morning, Your Honor. Kirma Dadush on behalf of Mr. Lester. Lester, can you please state your name for the record?
Yes, Paris Lester.
Okay, so Mr. Douche, let me explain something about what she did. So she didn't know what a shortstop was the last time we were here.
I have a
I did,
diagram.
hold on. I then sent you a baseball diamond with all, yeah, you got it.
I have a diagram for you
Uh-oh.
for a game that you won't understand.
Oh, no. So now she wants to play games with me.
That's what baseball looks like to me.
Wow, I'm sorry.
I appreciate that. It's Yellow's turn.
I don't even know what that is. That's what baseball looks like to her?
Looks like a house.
Okay, so I sent her a baseball diamond with all of the positions listed and their number next to them. She's showing it.
Mm-hmm.
The response I get back, I was trying to help her, was she called me a troll. I'm just.
I never said those
no, I'm
words.
just pointing that out what you did.
I never said.
No. You want an adjournment?
Yes,
Yeah,
please.
you may.
There are pending charges that are waiting to be authorized, so we are joining.
Additional charges against this defendant?
No, never. Yes, again.
So where are they in, do we know where they are in the system and how?
Your Honor, we have the warrant request, but I have to go through them. There's 3 or 4 of them.
There's 3, okay. And is this then the only thing holding him at this point? No?
No.
All right. Well, what I'll do then is I'll adjourn it out. Let's see where we are. I'll just go 2 weeks out, or basically 2 weeks out to July 3rd, 2025.
And for the record, Your Honor, we are, on his other cases, we are potentially working with CMH.
On
right,
those.
yeah, okay,
Got it.
thank you.
All right. And at this point, it's bond will continue. All right, thank you. This. Oh. I don't even know what that name is. That's what she gave me. It's some voodoo stuff. Court goes case people versus Dave Ellington. See, I was trying to help her out.
Ellington? And Jennifer Douglas.
You know what a shortstop is, right? No, okay, never mind.
Welcome back, Mr. Allen.
Wow. She said, welcome back. She did? Did she miss you? Huh? Why did she say that?
Well, I
There's
just
something
was
there.
acknowledging that,
No, something's up.
Your Honor, we are requesting a 2-week adjournment for mitigation purposes.
Any objection from the people?
Okay.
Probable cause July 3rd, 2025, 9 a.m. Bond continue.
July 3rd, 7-3, 9 a.m.
Okay. Court does call the case of the people versus Tyler Redmond. Thank you.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender Lauren Brown.
Oh. So bald head. Permission to practice is granted.
Thank you, Your Honor. Appearing with and on behalf of Tyler Redmond, please state your name for the record.
Tyler Redmond. Thank you, sir. All right, what are we doing?
At this time, we are requesting an adjournment to be assessed for the Drug Circuit Court, which is set for June
The
20.
Drug Circuit Court.
The Drug Treatment Court. Yeah,
Circuit Court. I don't know what that means.
Circuit Drug Court.
Okay, go ahead.
It is set for June 26th, so a date after
So
that.
they would be, they had their meeting on the 26th.
Yes.
Okay. Any objection from the people?
No, Your Honor.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Combined continue. What's she do? I haven't left to sign. Trying to be fancy. Oh, you got it. Court does call the case people versus Latosha Griffin.
On behalf of Ms. Griffin, can you say your name for the record?
Latasha Griffin.
Latasha Griffin.
Your Honor, we are going to be setting this for preliminary examination, please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available. The first preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond continue.
Thank you.
Court does call the cases of the people versus Leo Stringa.
Andrew Banish for the people.
Hannah Mackey on behalf of Mr. Stringer, who's approaching to my right. Please state your name for the record.
Leo Stringer.
Your Honor, we're respectfully requesting an adjournment to write up a plea offer form.
To do what?
We need to write a plea form.
Is this the only thing holding him?
Oh my.
Why is every question I ask her a mystery?
Feel the same way sometimes, Your Honor.
Uh-huh.
Said I feel the
Your
same
Honor,
way
it's
sometimes.
Wow.
It's not the only thing holding him in this county.
Pardon?
He has other holds in other counties.
Other
But in
places.
this
In
county.
this county, this is the only.
Probable cause conference July 3rd, 2025, 9 a.m. Bond continue. Did she give me a green sheet?
Oh.
Do you have a green sheet? Or you're just gonna hold it?
No, I'm gonna fill it out.
Oh, you haven't even filled it out. Okay, so the correct answer to that would have been no.
Green sheet. Technically, I have a green sheet.
This is like riding that bus. Demetrius Griggs.
Alexander on behalf of the people, Your Honor.
Stephanie Can on behalf of Ms. Griggs.
Ms. Griggs, could you please state your name for the record?
Demetrius Griggs.
And Your Honor, we are just setting this for a preliminary exam.
Discovery complete.
To my knowledge, Your Honor, yes.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination, July 1st, 2025, 9 a.m. That's before Judge Barr.
7 a.m. before, it's here.
I understand what?
Yes.
Bond will
9 a.m.
continue. Thank you.
Thank you.
Court does call the case People versus Larry Hickman recall.
People, Your Honor.
And good morning, Your Honor. Assistant Public Defender, Chinazi Kariaki, on behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
All right.
Your Honor, today's date and time set for a probable cause conference in this matter. The people did send over an amended complaint. I think he would need to be arraigned on the additional
Yes, he needs
charges.
to be arraigned on counts 3 and 4. So you can waive their formal reading.
We do waive formal reading of that, Your Honor. We stand mute asking the court to enter a not guilty plea on Mr. Hickman's behalf.
All right. Defendant having waived formal reading, standing mute to counts 3 and 4. Court will enter a not guilty plea.
Thank you, Your Honor. And in regards to the probable cause conference, we'd like to set this matter for preliminary examination, Judge.
You want this set for the prelim?
Yes, please.
And you're satisfied with discovery, even with the added counts?
Yes, we are, Judge.
All right. People have their witnesses available to first. Preliminary examination will be set July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Alicia Henderson.
Assistant Public Defender, Chinazi Kariaki, Your Honor, on behalf of Ms. Arlisha Henderson. Your Honor, she is not here right now. We have spoken to her. She's
What do you
en
mean,
route.
not right now?
She's just not here right now, Judge.
What's that mean?
She had an appointment this morning. She's pregnant, so she did have an appointment that she could not miss. But she says she's en route.
Oh, I'm supposed to have some sympathy.
No, I don't. That's not what we expect, Your Honor. I'm just giving.
That's not, she doesn't. Really?
If you
Well,
like,
no,
it would
you
be
go
nice.
ahead. I will let you make your argument.
It's Judge,
Your client's pregnant, had a medical appointment this morning?
That's correct,
Are you
Your Honor.
sure?
I am. Well, that's what she's told us, Judge.
Oh.
Yes. So we did speak to her.
Or you want me to issue a bench warrant?
I absolutely not, Judge. I'd ask that you pass this matter and see if I can get an ETA for her.
Why do I have a feeling this is gonna end up where she's on a bus?
I don't have pictures yet, but I can. And Judge, we do have a resolution in this matter too, but.
Specifically restorative.
I don't know what that is. But it's fine. I'll pass it.
Thank you so much, Judge.
Court does call the case People versus Dantes Williams.
Alexander on behalf of the people.
Good morning, Your Honor. Hannah Mackey on behalf of Mr. William.
Your name, sir?
Dante Williams.
Thank you.
Your Honor, I believe we would like to set this matter for preliminary examination.
All right. Did you wish to argue the bond? Your bond motion was also
Yes,
put
Mr.
over.
Brown will do that, if that's okay.
Pardon? Because I believe at this point his bond stands as revoked. Is that right?
That is correct.
Can I pass this matter, Your Honor, please?
Yes, this was set for
A bond, yes. Bond
the
violation.
bond as well as I think a PCC, so, but I'll pass it.
Thank you.
Court does call the case People versus Marcus Jones.
People.
Good morning, Your Honor. Constable Move on behalf of Mr. Marcus Jones in the hallway, Your Honor. Just
Okay.
I just tapped him just to speak.
Find out why they got their hand up. I don't have no idea. Oh, they just put it down.
we'll say your full name for the record, please.
Marcus Jones.
Thank you. Take your hands out of your pockets, please. All right.
Sir, today is the date and time set for probable cause conference. At this time, we're going to be requesting for about a month adjournment. My client is to be starting treatment on July 1st, and we would like to show court some progress so that we can get an offer for my client.
Starting what treatment?
He's starting outpatient treatment.
Yeah.
We're explain to the judge.
CMH, because I was off my medication for like a few years
Oh, okay, so you're working through CMH.
for treatment,
Pardon?
for treatment to be compliant with my medication.
Okay. Gotcha. Oh, no, we won't have the 24th. We don't have 24th. We only have the 22nd. All right. Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. That's a Tuesday.
Thank you, Your Honor.
Bond will continue. Thank you. I got one. Otherwise, it's not okay. Court does call the case People versus Dominic Kelly Payne.
Good morning, Your Honor.
Kesma Dadush, on behalf of Mr. Kelly Payne, stepping in for attorney of record, APD Alexis Plumai.
Okay. Mr. Payne, state your name, please.
Dominic Kelly Payne.
All right.
Your Honor, I believe Mr. Kelly Payne is supposed to be getting a bed at Spera today, which is the reason for Zoom.
Getting
a bed at Spera.
Okay. Is that where you are, sir?
No, not currently. I'll be there at 1 o'clock.
So you're requesting an adjournment?
Yes, Your Honor, we're going to be requesting an adjournment. She filled out a green sheet.
Well, I'll adjourn it to July 3rd, 2025, 9 a.m. so we can keep a status on it.
Thank you, Your Honor.
Thank you, Your Honor.
Fine, continue. Thank you. Court calls case People versus Nicole Knox.
Andrew Banners for the people.
Your Honor, Alexis Plumai appearing with it on behalf of Ms. Knox. Ms. Knox, could you state your full name for the record? Your Honor, today is the date and time for a probable cause conference. We have reached an agreement with the people. Ms. Knox is going to be pleading to an OWI second, which is a misdemeanor. I believe the court has that plea form.
I do have a plea form that indicates she's going to be pleading to an added count 2 of operating while intoxicated, second offense, a 1-year offense. Upon a successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, that is our understanding as well. And I also have a signed advice of rights and sentencing judge waiver form.
May I have her sworn?
Right hand. You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Nicole Knox.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes.
That's your understanding?
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
You're on probation. Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right, and because you believe that you are indeed guilty?
Yes.
I do have to advise you, ma'am, that if you do commit misconduct from the time, if I accept this plea, from the time of this plea up until the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, ma'am?
Yes.
You also understand that any sentence recommendation or evaluation in this case, the court would no longer be bound by.
Yes. I understand.
All right. All right, on date of February 24th, 2024, at the location of Michigan Avenue near Hamilton Street, in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes,
What did you have and how much?
I had one margarita.
Pardon?
I had one margarita.
One margarita?
Yes.
All right. Were you stopped by the police or was there an accident?
My. No accident. My car had, my axle had broke.
Your what?
My axle.
The axle on your vehicle broke?
Yes.
Okay.
So I couldn't move. I was stopped by the,
Yeah, usually you can't move without an axle. Did the police arrive?
yes,
Were you ultimately arrested?
yes.
Were you taken to the hospital or were you taken to the police station?
Both.
Was there a blood draw?
Yes.
What were the results of the blood draw?
Your Honor, it was 0.173.
0.173.
Yes, the blood draw.
How big was this margarita?
It wasn't that big.
It wasn't that big? You got to a 173 with one margarita.
I think I had drank it the day before or so.
Do you have any reason to dispute those blood test results?
No.
Had you previously been convicted of operating while intoxicated on or about August 13, 2014 in the Third Circuit Court and of operating while intoxicated on or about July 6, 2025 in the Third Circuit Court?
Yes.
Counsel, are you aware of any other threats, promises, or inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court ruling? Would it be proper to accept this defendant's plea guilty to this charge?
Yes, people are satisfied. Thank you.
Yes, Your Honor, the defense is also satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and screening assessment is ordered. Sentencing in this matter will be
July 23rd, 5 at 10 a.m.
July 23rd, 2025, 10 a.m. before Judge Fleischer. Are you on a tether or sober link?
And Your Honor, just to clarify, I apologize that I don't know this. Do you refer to CCOP or von Schwartz for screening pre-sentencing?
Well, this isn't mine, so you're going to have to ask
Judge
Barr's court who they go through.
Okay.
Bound with its conditions will continue.
Thank you.
Just like a festival site. It was one? Oh, that ain't right. That's a big old margarita. Yeah, please. If we could order one for the room. Court calls the case, People versus Quincy Jones, both cases.
And dance to the people. We're ready in this matter.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones, who appears to my right.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, also on behalf of Mr. Quincy Jones, and 21F10574.
Yes.
Your name?
Quincy Jones.
Counsel approach. don't even know why you're saying. Mr. Jones, I'll adjourn this out to June 26, 2025, 9 a.m. You might want to eat your Wheaties that day. It's going to be a long one. June 26, 2025, 9 a.m. Defendant's bond at this time is revoked.
Thank you so much, Your Honor.
All right, defendant's remanded. Court does call the case People versus Sheldon Lewis. Those are recalls.
And our Assistant Public Defender Counsel will base on behalf of Mr. Lewis.
Andrew Van for the people.
Your Honor, I just did receive a message saying that he's on his way, that he's on the bus. He's been.
No, you didn't.
I got it here.
No.
I got it right here.
No.
I've got it right here.
You had the nerve to come up and tell me on a bus.
May I approach, Your Honor?
No. Is that really what you're telling me?
That's
or did
really,
you talk?
That's really what I'm telling you.
Where's what's your name? You.
I wouldn't make
No.
this up. I wouldn't make
Wouldn't
this
make
up.
it up?
I would not. Not in front of you.
Another judge you might. Okay, I get that. Where's a bus from where?
Your Honor, I know he's in Ypsilanti. He's on his way here. I just received another.
Did Mackie tell you to say that? You don't know where he's coming?
I know he'll be here soon, Your Honor. If we could just briefly pass the matter.
You know he'll be here soon?
Yes, I do.
You have no idea if
I received assurance from his daughter that he's on his way here just a moment ago.
From where?
From Ypsilanti. She said he left about an hour ago. So I assume he'd be here very soon.
Just take a bus that long? I don't know. Ask Mackie. Mackie, does it take a bus that long?
Yeah.
It does?
I took a bus.
No, you didn't. No, I don't know. I don't even know why you're saying that.
I don't normally ask this of you, Your Honor. Just
no, you would. You absolutely would. I'll pass it.
Thank you, Your Honor.
If he doesn't show up, I'm putting you on a bus.
Fair enough.
I know. Been a day. Court calls the case People versus Derek Martin.
Stephanie, Stephanie Cannon on behalf of Martin.
Really?
Oh, I didn't even look, Your Honor.
Oh.
Your Honor, my client is expressing his sincere.
Do they not make them as they go under the ground? Either?
From here on out, but the shoes are nice.
What?
Your Honor, we're just requesting.
You like the shoes?
I like
Hey, Cannon. No, I don't want to hear about it.
We are requesting a 2-week adjournment. My client is of the understanding and knowledge that from here on out, he will dress in appropriate court attire.
Without a doubt.
Harbor Cause Conference, July 3rd, 2025, 9 a.m. Bond continued. Court calls case People versus Kevin McCullough.
Take the county to the people, Your Honor.
We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. McCullough. Your Honor, we received a communication from Mr. McCullough this morning.
He's on a bus coming down.
Not in a bus, Your Honor. He is at the Trinity Health the hospital. He does not have a release date. I was able to share the information sent with the prosecutor, Mr. Kennedy. We're asking for a 2-week adjournment in this case.
That, Your Honor, it may explain why he didn't appear at corrections, given that I believe he was checked.
How long's he been there?
6:50. believe is what you showed me.
Yeah, 6:15 is the date.
Well, if he's been there since 6:15, he didn't report to community corrections as previously ordered, and that was before that date. So that wasn't the reason for his failure to go over to community corrections.
Well, maybe he was feeling ill before that, Your Honor. You know, us men, we like to procrastinate and going to the hospital.
Okay, so here's what I've done. I'll adjourn it out. But he already has a bench warrant out because of his failure to appear. So I'm going to leave the bench warrant outstanding. I'll adjourn this. I have the thing for Trinity Health now, but I'll adjourn the probable cause to July 3rd, 2025, 9 a.m. So they'll have to do that, and then maybe I'll lift it.
Thank you, Your Honor.
Thank you, Your Honor.
What is she handing you? This is Mr. Brown on this case. She's handing you another green sheet on what? Something she didn't do before? Like all the way it's already gone, she's just handing it in now? Why? That's an old green. It's like that case was like hours ago, Mackie. That's all you got. Court calls the case, People versus Joseph Trim.
Send on behalf of the people.
Hannah Mackey on behalf of Mr. Trim. Oh, he's in the hallway. I'll go get him.
Good morning, Your Honor. Edward Dukes on behalf of Mr. Trim, who is approaching.
Your name?
Joseph Trim.
Thank you. Really? What?
Your Honor, if we could ask this for a moment, I didn't know I knew he was out of custody, but there's an argument regarding bond that I want to go over with him prior to discussing. I'd be asking for an adjournment, but I do know there's a bond argument as well.
He's out. You want? Okay, fine. I'll pass it.
Okay, thank you, Your Honor.
Court calls the case of People versus Mykesha Melchor.
Andrew Bench.
Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Melchor. Am I saying that right? Ms. Melchor? Yeah. Ms. Melchor, who's standing to my right. Your Honor, I do have a green sheet. I'm very hopeful that we're very close to a resolution. Ms. Melchor, I'm expecting documentation by the end of the day of her intensive outpatient treatment program. So I am asking for a brief.
July 3rd, 2024, 5, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Lanish Mitchell.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Mitchell.
Is that how we have it? So
yes.
Okay.
What's that?
All right, what are we doing?
Your Honor, upon speaking with Ms. Mitchell, I think it would be necessary for us to adjourn the probable cause conference. We need to do some further investigation based on the information we've received.
All right, I'll need a green sheet. Any objection? July 3rd, 2025, 9 a.m. Bond continued.
And we do want to address one aspect of bond. What's the date? June 19th? And where do you have to be? Your Honor, my client has a dance team. She is a verified dance mom.
Dance mom, dance coach.
a dance coach, and a dance mom. So her team is going to be, I guess, competing in Minnesota on June 19th. And she'd like permission to be able to travel with her team so that they can, do their thing.
You'll see us on YouTube.
I'm sorry?
You'll see us on YouTube.
You can see you guys on YouTube?
Mhm.
Yeah, me too. So. Are they any good?
Best.
Yeah, we're the best thing.
Why are you saying, have you seen me around?
What?
Have you seen them?
It's my client. I get all the way. They're gonna win.
Yeah.
So when does she want to go to Minnesota?
Well, the event is on the 19th, so tomorrow morning. We're gonna drive.
Till when?
After the performance is over, and we'll head back.
That doesn't tell me. I need a day. Is it gonna be that same day?
21st. It's a 10-hour drive, so it's 10 hours.
Why is everybody explaining all this to me? I understand how far Minnesota is.
Okay, well.
I just need to know, when do
21st.
you want to
after
go?
Tomorrow morning. Yes.
Till
the 21st.
And the good news, Your Honor, is she won't be taking the bus.
That was great.
It's on this floor.
I made it.
All right, defendant may travel to Minnesota the 18th through the 21st inclusive for dancing.
We teach
Is it a
everybody.
competition?
It's a performance for the Juneteenth parade, so.
Oh, well, you should have led with that. I mean, fine.
I was letting him talk.
Oh, you shouldn't do that. All right, yeah, absolutely, you can go now.
Thank you.
All right.
All right, thank you.
Good luck to you.
Thank you.
Troy. Court does call the case Boo versus Keith Moore.
Andrew Banner for the people.
And Alex Warren Green on behalf of Mr. Moore. Your Honor, does the court see Mr. Moore on Zoom? I'm not sure if he. Okay, Your Honor, I talked to Mr. Moore's.
Down the bus with the other guy. Is that what you're gonna tell me?
No, I talked to his community mental health caseworker. She says that Mr. Moore is having some mental health issues right now. I understand CMH has the court's Zoom link, so I wasn't sure if they were going to log in. Your Honor, I'd ask for either an adjournment so that I can, so we can get him to a better place and I can evaluate his competency, or ask the court to pass this matter so he can appear on Zoom. Thank you, Your Honor.
I haven't said anything. I'll pass it.
Thank you, Judge. I appreciate that. I will get in touch with his caseworker right now.
Go on.
Thank you, Your Honor.
It's not going. Court calls the case People versus Megan Moses.
Anna Mackey on behalf of Ms. Moses, who is appearing via Zoom.
Andrew Banner for the people.
Oh, sorry. Ms. Moses, please state your name.
Hi, I'm Megan Moses. Sorry, I've got a puppy in the background. Please.
Did you?
That's her.
Okay. Your Honor, we're respectfully requesting to adjourn this matter to give Ms. Moses more time to pay restitution off.
The rest. So how much more time is she gonna need to pay it off?
We're still in discussion about how much the restitution actually is.
So we don't even know how much she's supposed to pay?
We do not.
Well, from what I've
When are we
heard,
gonna get that? When are we gonna get that information?
I think there was supposed to be a restitution hearing first before we move forward because there was some issues with what the amount was.
The amount was conveyed, but there was a dispute from the defense or defendant about it. So I would.
And so how's she gonna pay if you guys aren't I mean, what are you guys trying to do? Besides irritate me?
Your Honor, we were given a number at her second hearing, I believe, and then the number increased by a couple $100 somehow at the third hearing. So
I feel like there's more to it than that. What I've heard and what I talked to with a public defender yesterday was she was also adding her therapy costs and her lost wages for going to therapy. So the restitution I was going to start a payment plan, and then the restitution just kept going up and up. So the payment plan wasn't going to work. And it's just above and beyond what I can even afford without having a steady income or a vehicle or a car, or even a steady home at the moment. So that's why we were going to have the hearing. So it could go back to just the fines and costs. And
what hearing are we having?
Your Honor,
other than this one, which is going nowhere?
Can we adjourn this matter so we can, Ms. Moses?
Yeah.
Can we adjourn this matter so we can discuss with the prosecution what to do moving forward?
Yeah. All right.
July 3rd, 2025, 9 a.m. We can't do anything. You need to set this for a restitution, or not a restitution here, or exam, because I mean, if there's not going to be an agreement on a number for her to pay and then get a deal, we're wasting time.
Thank you, Your Honor. And may I request to address bond, please?
To what?
A bond modification. May I request to address?
Oh, now you want a bond modification. Go ahead.
Your Honor, Ms. Moses was placed on a tether in April, I believe, for a failure to appear to a court hearing when she did not have access to the internet. She has complied with all of her court orders since then. She has shown up to all of her hearings since then. So we asked this court if she could remove the GPS tether. Ms. Moses rides a bike to work, and it gets in the way of that as well. It just chafes her leg.
Any response from people?
Yeah, I'll leave that to your discretion. My main concern is that the any or all no contact orders remain.
I'm going to deny the modification at this time, and we can address it on the 3rd, potentially, and then figure out what we're doing.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Nicole Nelson. You weren't.
Oh, got the truth.
Good morning, Your Honor. Student Attorney Andrea Sabri on behalf of Mr. Nicola Nelson.
Oh, Andrew Van, excuse me.
Your Honor, Mr. Nelson is not present. I have made multiple attempts to contact him, but I do not have an explanation regarding his absence, unfortunately.
Bench warrant will issue the failure to appear. Bond in each of these cases will be set in the amount of $10,000 cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Antoine Patterson.
Chicken candy for the people, Your Honor.
Assistant Public Defender Sandra White on behalf of Antoine Patterson. Please state your name.
Antoine Patterson Sr. Thank you.
Yeah, and I've been talking with the prosecution, and I believe Mr. Bellinger has been handling this matter, and we're asking for an adjournment. They're still waiting us.
Do we have any idea when those might be coming?
No, but we'll look into it.
The green sheet, July 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
Phelan, this is your name for the record.
Tawana Taylor.
Thank you.
Your Honor, we are going to be setting this for preliminary exam, please.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available the first.
Yes, Your Honor.
Preliminary examination will be set in person, July 1st, 2025, 9 a.m. That's before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Tyler Pittman.
Andrew Banner.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Pittman. Mr. Pittman, could you say your full name?
Tyler Pittman.
Your Honor, we are requesting an adjournment at this time. We did recently provide the people with a mitigation report, so they will need some time to review that, and hopefully we can negotiate an offer. And I do have that green sheet here.
July 3rd, 2025, 9 a.m.
Your Honor, would it be possible to actually go out one more week? Mr. Pittman stated he has trouble getting off work and school on 2 weeks' notice, so if we could go 3.
Is that correct, sir? July 10th will give you enough time then?
Yes, sir.
All right, July 10th, 2025. All right, thank you, sir.
Thank you.
Court calls case People versus Jeremy Schultz.
Assistant Public Defender, on behalf of Mr. Schultz, he's in Wayne County Jail. I'm not sure if, I know it was adjourned previously to writ him out, or at least that's what my notes say. That being said, I was going to request an adjournment anyways, because he just said court yesterday in Wayne County. And so he is going to be held in Wayne County until July 7th, which is his next court date, his sentencing in Wayne.
July 7th?
Correct.
I did send the red email. I think it was.
Oh, that makes sense.
Well, if I set it for the 3rd, he doesn't have court on the 3rd.
Correct.
July 3rd, 2025, 9 a.m. That way it'll be enough time for a writ.
Thank you, Your Honor.
Court calls case People versus Kirby Snyder.
Andrew Banner.
Stephanie Han on behalf of Ms. Snyder.
Hello, what's your name?
Beverly Snyder.
Thank you.
And Your Honor, we're going to ask for I think I put a 3-week adjournment on there. We're going to have her screened for sobriety court, but we're also looking to negotiate with the prosecutor on this matter.
July 10th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Case of the People versus Matthew Vermillion.
Ally's on behalf of the people, Your Honor.
I'm Lily Gagne, Assistant Public Defender with and on behalf of Mr. Vermeulen, who's standing to my right. Could you state your name for the court?
Matthew Vermeulen.
And Your Honor, we are respectfully requesting an exam date in this matter. I do believe discovery is complete.
People have their witnesses available the first. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Cynthia Weber.
And Alex Warren Green on behalf of Ms. Weber. State your name, Ms. Weber.
Cynthia Weber.
Your Honor, today's date and time for probable cause conference. I believe we have reached a resolution. I have a plea form from the people right here.
I don't have it.
Thank you.
She'd be pleading to operating while intoxicated, second offense.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Cynthia Weber.
All right, ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative program support deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes. Sorry.
And understanding, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 1483 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you that your entry of a plea in this case could be a violation of that probation. You understand that?
Yes.
You understand that if it is considered a violation of that probation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
Yes.
And understanding that, you still wish to plead guilty?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you're indeed guilty of this offense?
Yes.
I would also have to advise you, ma'am, that at the time of this plea, if it is accepted in time of sentencing, if you do commit misconduct, then any sentence recommendation or any agreement or evaluation is basically voided and court is not obligated to follow that. You understand that?
Yes.
You also understand that if you do commit misconduct, you would also not be entitled to withdraw your plea.
Yes.
Hang on. On the date of December 30th, 2024, at the location of Hadley near Bartell in Linden Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
3 to 4 beers as well as 4, maybe 5 shots.
Were you stopped by the police or was there an accident?
Tree accident.
You ran into a tree?
Yeah.
Did the police arrive?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
And what were the results of that blood draw?
0.112, Your Honor.
Do you have any reason to dispute those blood test results?
No.
Counsel, have there been any other promises, threats, or other inducements which have led to this plea that were not stated on the record?
None from the defense, Your Honor.
No.
Has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation sentencing in this matter will be
August 4th, 2025 at 9 a.m.
August 4th, 2025, 9 a.m. before Judge Fleischer. Our bond will continue.
Thank you.
Thank you, Your Honor. I provided the court with a referral to the sobriety court. This plea is in no way contingent on her screening or acceptance, but I'd ask the court to consider signing that. I talked to probation with the sobriety court, and they advised that they could complete a screening between today's date and the sentencing date. Thank you, Your Honor.
Court calls case people versus Taylor Adams.
Advantage for the people.
Your name, sir?
Taylor Adams.
All right.
Your Honor, I retained an attorney, but this is now his second. He didn't show up the first time, and now it's the second time that he hasn't showed up. So I'm asking for a public defender, please.
All right. When you say you retained, did you pay him money?
No, his check is here.
Pardon?
His check is here. That's what I was gonna do the first time. Give him the money when he gets here. He lives his office is out of Grand Rapids.
Oh. The public defender case.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams. Your Honor, we're requesting an adjournment. I apologize. I received Mr. Adams' contact information. We just need an adjournment to receive discovery, review it with our client. I'll complete a green sheet for the court. I apologize.
Yeah, I'll adjourn this out to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
We'll be in touch. Okay. Court does call the case people versus Willis Cherry.
Introductions for the people.
David I. Goldstein appearing on behalf of the defendant. State your name, sir.
Willis Cherry.
Your Honor, I'm prepared to ask for a preliminary examination, but I did inquire of Ms. Douglas whether there are any, I do have the written discovery. I don't know if there's any videos. If there aren't, we're ready to go to an exam.
There are videos.
How soon can you get to defense counsel?
I'm showing this as having been discovered, so let me.
Yeah, that would have been to public defender's office.
So I guess it went to the public defender. I can get that done.
Probable cause conference. Are you available the 3rd?
I'm sorry, Your Honor?
Are you available the 3rd?
Yes.
July 3rd, 2025, 9 a.m. Bond continues.
Your Honor, with regard to the issue of the bond, and I'm sorry I didn't get a chance to talk to Ms. Douglas about that. Mr. Cherry is employed, and a lot of his employment is in Lucas County, Ohio, the Toledo area. He is on probation to a district court. They have already given him permission to travel to Ohio, but that's conditional upon you granting that permission also.
Any response from the people? What district court granted him?
15th, Your Honor.
Or is okay with it. I won't.
Really? Okay. I'll indicate that defendant may travel to Ohio for work purposes.
Thank you, Your Honor.
Thank you, Your Honor.
My last. Oh. Court does call the case People versus Antoine Pitts. Just that one again.
Ms. Douglas, call Pitts, Antoine Pitts.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant.
He's not here.
Your Honor, Mr. Pitts is having some health issues. He has been recently diagnosed with lupus. He has a probation violation in front of Judge Hammoud. The public defender has been presenting to Judge Hammoud notices from the doctor regarding he's been ordered to bed rest and oxygen therapy. I was hoping to have him. I have several of them on my phone. I was hoping for a more recent one. The most recent one I have is from May, but they've indicated he has lupus and has issues with breathing.
Yeah, but we keep letting him out. He doesn't appear. Last time that you were here, I think I told you I was leaving the bench warrant out. I was waiting on medical. I never got any medical to indicate anything.
Okay, I can get those.
And I left the bench warrant out. And now he goes through the arraignment process, gets released again, supposed to get to community corrections, doesn't go.
Your Honor, I'm assuming he's not going because of his medical problem.
I don't know that.
I was, okay, I'll get that stuff to you, Judge. I've got some.
I already issued this bench warrant.
Yes.
He's already got a bench warrant outstanding at this point.
Okay, I'll get the medicals to you as soon as I can, Your Honor.
All right. So I'm just going to leave the bench warrant out. I'll give a new date on it, but July 3rd. And if he shows up, he shows up. But otherwise, in the interim, there's a bench warrant that's outstanding.
And you'll have the medicals before then, Your
Honor. Recalls the case People versus David Witherspoon.
Joe Simon on behalf of Mr. Witherspoon, Your Honor. What's your name again, David? David Witherspoon?
All right. The issue in this case is I did call over there are no other violations, correct?
That is correct. Pointing against late test.
There was a late test yesterday. Why?
It was 7 minutes. Well, I asked my client and he basically told me he was worried he was going to go to jail today and he was just.
Well, he should be.
Yeah, because I told him to be. And, but anyway, he has he missed the time slot and then just no good explanation other than he just missed and then he panicked and tested 7 minutes later. But he also wants to let you know he tested this morning too. And there was no violation.
Anything you want to say regarding this bond violation? Because I don't even understand.
He had a bad day and night where he's going to admit drinking alcohol. So that was June 3rd, segue into the morning hours of June 4. And since then, he's been completely compliant other than that 7 minutes. He also wanted to go over to a scram tether because he's so panicked about missing times, etc. He's maintaining that since he'll admit to drinking on the 3rd, but since he's been completely sober. Also, regarding the case, we've reached a resolution between the parties, but I just checked with Mr. Heaton, who was here today from the 14A court regarding sobriety court screening. And I know what my client needs to do. If we resolve the matter the way that we principally constructed, I want to get my client screened and accepted into the sobriety court in 14A first. And I think that will only help him in his issues. If in the interim, he can be on a scram. And if all of that is acceptable to the court, I'd request July 17, because it's going to require a few things for him to get done before being accepted.
Mr. Allen. I will adjourn the probable cause to July 17th, 2025, 9 a.m. The defendant having admitted to the violation, I'm going to sentence the defendant 7 days in the Washtenaw County Jail. So he'll be released and then can do that upon his release. He's to be placed on a scram teller prior to his release.
Thank you. So, Your Honor, my staff will try to make arrangements with the community corrections in my absence to make sure that he gets that before release. But in the court, as the court knows, sometimes we have trouble with that. Is there anything?
Well, we will prepare an order that needs to be placed on the scram prior to release.
I'm saying for community corrections, the jail always is aware of that, but sometimes community corrections doesn't know to do that. You know what I'm saying?
They're supposed to be contacted, I think, by the jail. That's how that's supposed to happen. But
I've had trouble with that before. We'll do all we can. Thank you very much, Your Honor.
if you have an issue, let us know.
Thank you, Your Honor. That was July 17th. Thank you.
Yes. Court calls the case, recalls the case, people versus Alicia Henderson.
Andrew Banish for the people.
Are we ready on that?
I'm gonna say no.
Court calls case, people versus Dantes Williams. Are we ready on that one?
Yes, Your Honor.
Okay. Well, they call for him. Court does, well, that one's coming out. Court calls case, people versus Sheldon Lewis. Is that? This is on the bus.
Yeah.
Sheldon Lewis? Oh. Was he driving the bus? Yeah. Or he wasn't driving it, but.
You're ready on this matter, Your Honor, and here he is.
Here he is what?
He was on the bus and he came.
I know. Did he leave all of his pants on the bus?
Yeah.
We won't have that happen again, will we?
Assistant Public Defender Constable Basie on behalf of Mr. Sheldon Lewis, who was present to my right. Can you say your full name for the record, please?
Yes, Sheldon Lewis.
Your Honor, we're going to be requesting an adjournment for some video discovery that our office has not yet received.
July 3rd, 2025, 9 a.m.
July 3rd.
All right. Oh, that, yes, that's right. Court does call the case, people versus Dantes Williams.
Alexander on behalf of the people, Your Honor.
Ron Brown appearing on behalf of Mr. Williams, Your Honor.
All right, I have before me a plea form in this case that indicates that the defendant is going to be pleading guilty to an added count 4 of aggravated domestic violence to 1 year. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. There was some issue because part of this case had been bound over, but then the case got set back for further testimony regarding an additional charge. I spoke directly with Judge Slay. What she had indicated is that those counts, so after I take this, because those counts exist in circuit court, there would have to be a nollie pros filed with the circuit court to get rid of those cases. I can dismiss them here, at least as a record, but those cases are up. So. All right.
Your Honor.
Yes.
Also, I believe party stipulator agree that he would receive sentencing under section 7694A.
Yes, that is on the plea form.
And that he would agree to no contact with
Ms. No, not to contest her PPO.
Exactly, Your Honor. Which has already been done.
Heaven's work.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Dante Williams.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of aggravated domestic violence. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You have signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No question, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes.
Yes?
Yes, sir.
I also have to advise you that if there's any misconduct committed by you between the time of the acceptance of this plea and the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, sir?
Understood.
And you also understand that any sentence recommendation and or evaluation, which may include the 7694A assessment, would also not have to be followed by the court. You understand that?
Yes, sir.
Counsel, is counsel aware of any pleas, promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule and would it be proper to accept this defendant's plea?
Do you need a basis? For the
Pardon? Did I not take a factual?
Factual.
You're right. I was so concerned making sure I complied with the new court rule that I haven't. I do have to take a factual basis because it's not in front of me. Thank you, Mr. Brown. On the date of April 2nd, 2024, at the location of 2017 Medford Road in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do on that date involving a Zaylen Gaynor that makes you think that you're guilty?
We got into an altercation and I scratched her.
You what?
I scratched her face.
All right. And who is she to you?
Oh, she was my girlfriend at the time.
All right. You didn't have permission to lay your hands on her in that fashion on that date, did you?
No, sir.
And it was not an accident on your part?
No, sir.
Counsel, have I complied with the court rule now? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. You count 4. Counts 1, 2, and 3 are dismissed, although 1 and 2, there needs to be the nollie filed circuit court. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. before Judge Perry.
Your Honor, may I address my?
You may.
Your Honor, my client tells me he's been in jail about 9 months. Is that accurate?
I don't know.
Oh, strike that. Strike that. He has not been out 9 months. Now that he's pled to a misdemeanor and the felony charges have been dismissed, I'm asking the court to consider release custody possibly on a tether so he can get back to work. He would stay at 19963 St. Aubin in Detroit, 48233, and have no contact with the complaining witness.
I don't need a response because I'm not going to release him prior. You can take that up with Judge Perry after after he's seen by probation for a screening assessment.
Yes, Your Honor. So bond continues, but once you're seen by probation, call our office. We can take a motion up in front of you. Here's a reminder of your court date and time.
Thank you.
Thank you. Go with the court office.
Court calls the case, People versus Joseph Trim.
Allie Zend on behalf of the people, Your Honor.
Thank you for that pause, Your Honor. Edward Lucas on behalf of Joseph Trim, who is approaching.
Joseph Trim.
Your Honor, I just was appointed to this case. I'm asking for an adjournment, obtain discovery, and like to address his tether bond condition.
Go ahead and address tether. I'll grant the adjournment.
Your Honor,
July 3rd, 2025. 9 a.m. Yes, that's the bond.
Your Honor, as to bond, he has the tether and a no-go to an address on International Drive. It's his parents' residence. The parents are not associated with, I guess, the charges in this case. It's because of the complaining witness lived on either below or above his parents. And so he has a no-go to there. His parents are relatively dependent on him for medical care for his father who has cancer. It's our understanding that the complaining witness has moved out of town and is no longer living at that residence. That's since been rented to another individual. I've told this to the prosecutor's office. They may be objecting to have it.
Pardon?
I believe the prosecutor's office is objecting. I don't think they've confirmed that yet, but I'm attesting to the court that that's the case and that she has moved.
That's correct. We have not had confirmation that she's.
Bond modification or change.
Okay.
Subject to seeking some type of confirmation regarding that.
Okay.
That'll be handled by staff. Okay.
Thank you. Thank you.
Bond will continue. Thank you.
Thank you.
Court recalls case of the People versus Keith Moore.
Excuse me, Andrew Bannis for the people.
And Alex Warren Green on behalf of Mr. Moore. Your Honor, I'm not sure if he's on there. If he's not, I have not.
Alex Moore. Or Keith Moore, excuse me. Keith Moore. No response.
And Your Honor, his caseworker has not got back to me. I appreciate the court's accommodation.
Will it this time issue a bench warrant bond 10,000 cash here? That warrant will issue immediately.
This is a jury trial. Not today, of course, but I mean, this is scheduled for a jury trial, so I can actually get involved in settlement negotiations, whereas I could not and would not if it was a bench trial. So, John, why don't you take them to a conference room that's not going to be used? And then you guys let me know how you're progressing periodically, okay? Thanks. Officer, what do you have?
He's got a sign on record, Your Honor.
Okay, come on up. Alicia Lizella Parks, 25B703313. Good morning. Your name?
Officer Water, Brownstone Police.
How you doing? Good. You're here for a signing on record and an OWI occupant less than 16 and a super drunk and an OWI. 3 counts. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Okay, you can go ahead and proceed.
On 12/26 of 2024, I was dispatched to the area of Dix, Toledo, and I-75. Dispatcher received reports of a female on the road flagging people down. When I arrived, contact with Alicia Parks, suspect.
Wait, Jen?
I'm sorry.
Okay, go ahead.
I made contact with Alicia Parks, the suspect in this case. She smelled, her breath smelled of odor of alcohol and was unsteady on her feet. She had told me that she was in a vehicle and that Priscilla Jones had taken the vehicle and left the area. A few minutes later, Priscilla Jones called dispatch advising that they were on the side of I-75 north of King Road, also in Brownstown. I had transported Alicia Parks to that vehicle, and when we got there, I made contact with Priscilla Jones. She and two juveniles in the back seat, not in seatbelt, not in the car seats, I'm sorry. Priscilla Jones, during an interview, told me that Alicia Parks had driven them there, pulled over on the side of the road when she got a notice on the dashboard that the key wasn't in the vehicle.
Yeah, what?
The key was not in the vehicle. They pulled over and Alicia Parks got out of the vehicle and took off walking. I then asked Alicia Parks if she had driven the vehicle to that location, and she told me yes. I asked her if she had any help.
To the location where you picked her up and transported her over to the other vehicle.
Correct. So,
Okay.
yep, I-70, southbound I-75. She told me she had driven the vehicle there, and she told me that she had not had any alcohol to drink after she got out of it. Put her through field sobriety tests, horizontal gaze nystagmus, the walk and turn. She did not complete the one leg stand due to her inability to stand up, and eventually she was arrested for OWI. She was taken to the Brownstown Police Department, read her chemical test rights, and then I took her to Henry Ford Brownstown to complete a blood draw. Once the blood draw results were back, it was at 0.25.
And the two children that are identified in the complaint, how old were they?
One would have been just under 1 year old, and the other one would have been around 3 years old.
What is Alicia Parks' relationship with them?
I'm sorry, yes, I should have said that.
That's okay.
She's their mother.
Okay, good enough. And you said it was a 0.25?
Correct.
Based on your sworn testimony, I find the crimes of OWI occupant less than 16, super drunk, and OWI were committed. There's probable, John, will you hand him this or Tabitha here? There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issuance of the complaint warrant. You can approach and sign the complaint there, okay? All right. Record should reveal that Officer Waterworth signed the complaint. The court is signing and dating the complaint and the warrant for the arrest of the defendant, Alicia Lizella Parks. All right, you're all set. We'll put this warrant into lien. Maybe you should notify her to appear here, okay? Have a great day. Thank you. Forest Health versus Deidre Perkins, 2404713. Is Deidre Perkins here, Jennifer? Do I have anybody out there on Forest Health versus Deidre Perkins? Again, 2404713. Ernest Mcuan versus Jamie's Attic LLC, 2500522R.
I don't see John out there, Your Honor. I don't know where she went.
We lost you out there. Okay, thanks. What's your name, sir?
Jerry Extra.
He's 9 o'clock.
Okay. Mr. Strauss, good morning. What case are you here on?
No, it's on serious. Capital One, be serious. We just were in the breakout room. I was just talking with opposing counsel. Suzanne.
Capital One versus Serreris?
Yes.
Call that Capital One versus Christine M. Serreris, 2500956. Good morning.
Good morning, Your Honor. Sazan Barta, P65425 on behalf of Capital One Bank.
Mr. Strauss?
Yes, 48673.
All right. Well, what do we have here? Do you want me to just give you dates or is there a resolution?
Just some dates, Your Honor. We have many cases with Mr. Strauss. We get almost 100% of them resolved. So just some time, 60 days, and then maybe come back.
All right. Just give me 1 second here. Today is the 17th. Uh, 65425. Mr. Strauss, I'm sorry, what is your P number again, sir?
48673.
All right. All right. I'm going to give you a discovery. We'll just call it by, say, August the 15th. No motions heard on the date of trial. I'm not going to order ADR. Witness lists are due July the 15th. I'm not going to do a settlement conference. Nobody's demanded a jury. We're going to give you a bench trial date. Jennifer, sometime the latter part of September. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 7 days before the trial date. All motions for summary disposition have to be filed and heard not later than 20 days, excuse me, before the trial date. Is there anything else I need to include in this order, gentlemen? Mr. Barta?
No, sir.
Mr. Strauss?
No, we're fine, Your Honor.
Okay, have a good day, gentlemen. I'll send this out to you. Thank you.
Judge, that date would be September 22nd at 10.
Oh, thank you.
No problem.
September 22nd at 10 o'clock in the morning will be the bench trial date, and I'll have that right in here, okay?
Okay, great. Okay, have a good day, everybody. See y'all.
Thank you.
Bye.
All right. Do I have Forest Health here versus Perkins?
Judge, they're still in a breakout room.
Citibank versus Carlo Imprada.
They're in a breakout room as well. I have Ernest Mcuan versus Jamie's Attic ready.
Ernest Mcuan versus Jamie's Attic LLC, 2500522R. Appearances, please.
Good morning, Your Honor. Billy Joe Taylor, P number 82278 on behalf of the defendant, Jamie's Attic LLC.
Okay. Mr. Mcuan, your name?
Ernest Mcuan, Your Honor.
Okay, just give me 1 moment, please. Taylor, I wrote on the wrong thing. That's for defendant. Okay. Did you two talk at all, Ms. Taylor?
Yes, Your Honor, we did. There's no, it's futile right now. So defendant has completed discovery. We are going to be filing a motion for summary disposition on this matter.
Let me just read this, please. Any dispute as to whether or not the defendant sold his tools?
There's no dispute to that, Your Honor, but to the knowledge of which tools, this is, without going into too much, is an estate sale, and the sales aren't monitored. The rooms aren't monitored, and plaintiff left his tools in one of the rooms and left for 45 minutes.
All right. Sir, do you want discovery? That's the exchange of information. If you want to get anything from them, documents, send interrogatories, anything along those lines, I can order discovery. She says that the defendant does not need discovery. Do you want any discovery?
No, Your Honor.
Okay.
Just to clear the record, Your Honor, we completed discovery. I did do interrogatories, Your Honor.
You already did those?
Yes, Your Honor.
Okay. Just remember, next time you need an order of the court or leave to conduct discovery in district court, I'm not quarreling with it, but you guys did, if you guys did it voluntarily, that's fine, but, all right. Witness lists are due by July 15th, 2025. I'm going to say no discovery permitted. The parties agreeing that they need not conduct discovery. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. I'm going to go ahead and set a trial date in this. Jennifer, we can set the same day as far as I'm concerned.
September 22nd. Do we want to go that far? Okay.
At
10 o'clock.
Thank you, Your Honor.
Okay, so that's what I'm doing. Give me 1 second here. Yeah, no adjournments of that though, okay, please? I'll see you guys September 22nd. Have a great day. Thank you very much. We'll send out the discovery order, and you should read that very carefully. No motions on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Thank you very much.
Duly noted. Thank you, Judge.
Thanks.
Your Honor, the Forest Health is ready.
Forest Health Medical Center versus Deidre Perkins, 2404713. Good morning, Mr. Collins.
Good morning, Judge. How are you?
Yourself?
My car's in the shop, so I'm subbing from home right now.
All right. Your appearance?
For the record, Stuart Collis on behalf of the plaintiff.
Good morning, Ms. Perkins. Your name?
Hi, I'm Deidre Perkins. How you doing this morning?
Not too bad. How about you?
I'm wonderful. Thank you.
What is this, over medical bills?
Yes, Your Honor.
You don't know these, ma'am?
No, it's not like that. It's just a misunderstanding.
Okay, tell me what the misunderstanding is.
Well, I have a surgery with Forest Medical Center, and before I had surgery, I signed some paper because they wouldn't let me have surgery until I paid them $1,600. So I was thinking that covered the surgery, but it didn't. It covered the surgery, but outside of my other medical bills from having the surgery, that's what they ain't covered, So I was under the impression that the bill was paid, and I didn't pay the bill.
Do you have anything in writing that says that would be the extent of the bills from Forest Health?
I had to look, but
here's what I'm asking you. Do you have any reason at this point to dispute that you owe this money?
No, because it was me. Everything was on the paper was dealing with the surgery. Yeah.
So do you agree that they're entitled to a judgment?
Yes. Yeah, I agree.
Did you two go into a breakout room and speak?
We actually worked this out, Judge.
Oh, good. Let me hear it. Sorry. Good.
So,
Okay.
Your Honor, we're going to enter into a consent judgment. I just going to need permission to sign Ms. Perkins' name. Damages $3,725.46. Court costs $187.84. Statutory attorney fee is $75. Total balance $3,988.30. Ms. Perkins can make payments to my office at the rate of $65 each month, starting June 27 of 2025. Should defendant fail to make a timely payment, plaintiff may file an affidavit of noncompliance to set aside the payment agreement. Interest accrues at the statutory rates per Michigan, and that is some of it.
All right, ma'am, do you understand what Mr. Collis just said?
Yes, sir. I understand.
He's telling me you agree that a judgment will enter in favor of the plaintiff and against you in the amount of $3,988.30, that there will be an installment payment order contained within that proposed consent judgment that calls for payments at the rate of $65 per month, beginning June the 27th and the 27th of every month thereafter until paid in full. Do you agree to those terms?
Yes, sir.
And you agree that you owe that amount?
Yes. Yes, I did.
Mr. Collis have your permission to sign your name to that proposed consent judgment?
Yes, we can.
I'm sorry?
Yes.
All right, so you understand, as long as you make those payments, they cannot garnish wages. They still could, if some choose to, some not, they still could garnish tax returns and bank accounts, but they could not garnish wages. Do you understand that? Ma'am?
I think she froze.
I know. Jen, you want to kick her out and let her be?
Yep, I will remove her, so then she's got to dial back in.
All right, Ms. Perkins, do you understand what I last said? That is, as long as you make those payments as agreed upon, they cannot garnish your wages, but they could garnish, if they chose to, bank accounts and tax returns. Do you understand that?
Yeah.
And again, Mr. Collis has your permission to sign your name to that proposed consent judgment. Is that true?
Yes, that's true.
Any questions, ma'am?
No.
All right, have a great day. Thank you. Thanks, Mr. Collis.
Thank you, Judge. Good seeing you.
You too.
Thank you,
Citibank,
Mr.
Citibank versus Carlo Imprada, 2500943.
Good morning, Your Honor. Brian Bruin, GROEN, Timbers 56673 on behalf of plaintiff Citibank.
Mr. Imprada, good morning to you, sir. Your name?
Carlo Imprada.
All right. Did you talk at all, Mr. Mr. Groen?
That's okay, Your Honor. We did, and we have actually worked out a payment plan on the full balance in this matter.
Why don't you go ahead and put the terms on the record?
Thank you, Your Honor. The total charge-off or damage amount was $4,833.75. We've incurred court costs of $151.79, comprised of a $75 filing fee, service fee of $56.79, and a $20 motion fee. So we're looking at a total consent judgment of $4,985.54. The defendant will make $150 monthly payments beginning July 12, 2025, and then on the 12th day of each month thereafter. As long as he does not default on payments, the plaintiff will not file any type of garnishments, including wage, bank. And Citibank does not charge any type of post-judgment interest, so the interest will be 0%.
Do you understand and agree to those terms, Mr. Imprada?
No.
Do you understand that he thinks And this going to be in the form of a consent judgment, correct?
Correct, Your Honor.
So you understand he's going to submit a proposed consent judgment to the court, which will call for payment for a judgment of $4,985.54, with payments to be made at the rate of $150 per month beginning July 12th of 25. So long as you do that, they will not only not garnish your wages, they won't garnish bank accounts or tax returns. Do you understand that?
I do understand that, Your Honor.
And you agree to those terms?
Yes.
Does Mr. Groen have your permission to sign your name to that proposed consent judgment, which he will submit to the court?
He does.
Do you have any questions?
No.
Okay. I wish you well. Thank you very much. Thanks,
Thank
Mr.
you, Your
Groen.
Honor.
I will email you a copy as well, okay? So that way you have a copy right away.
Thank you.
You're welcome.
Thanks.
Bye-bye.
Do I have Credit Corp and Baker?
I am here on that one as well, Your Honor.
Right. Credit Corp Solutions, Inc. versus Bridget Baker, 25-01007.
Once again, Your Honor, Brian Gruen, GROEN, number 56673, on behalf of Plaintiff Credit Corp Solutions.
Ms. Baker, you have to start your video and unmute. Bottom left-hand corner of your screen, please. There you, no.
There we go.
There you go.
Okay.
Good morning. Your name?
My name is Bridget Baker.
Good morning. Mr. Brown, your appearance?
Once again, Your Honor, Brian Gruen, GROEN, number 56673, on behalf of plaintiff.
Any resolution on this one?
Not today, Your Honor. Ms. Baker is going to be looking into her finances, and I have given her my direct line, so she's going to call me. In the interim, we would just ask for a scheduling order with 60 days discovery.
All right. Ma'am, I want you to understand, just so you know, and I'm not suggesting in the least that you owe this debt, but if you do owe the debt and it's a matter of the money, you can always agree to a judgment, and then the two of you can get together and agree to an installment payment order. If he thinks, or the plaintiff thinks, that you're not paying enough based on your income, you can come before the court and I will make that determination, okay?
Yes.
All right, so I'm going to give you discovery until August the 17th. No ADR. All motions for summary have to be filed and heard not later than 20 days before the trial date. Trial date will be September 22. That will be at 10 o'clock in the morning. There's no jury. I'm going to have the witness lists have to be filed, identifying the names of all witnesses by July the 17th. You don't have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. Again, trial date will be September 22 at 10. And we will send out this scheduling order. You should have it no later than Monday, okay? Any questions, Ms. Baker?
Not at all.
Discovery is the exchange of information. So if they have something in their possession that you want, you may request that in writing, okay?
Yes, thank you.
All right. Good luck. Thank you. Thanks, Mr. Groen.
Thank you, Your Honor. I appreciate it.
Thank you.
Good luck, ma'am. Thanks. GTSC Warehouse LLC versus Christopher Anthony Adkins.
Judge, the parties are in a breakout room. Mr. Barter on the Bank of America case, though, is back out, but the defendant has not come out of the break. Oh, here she is. Miss Hazy's here
Bank
now.
of America NA versus Tara Lee Hazy, 25-00721. Good morning again, Mr. Barta.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of Bank of America.
Ms. Hazy, you have to start your video, ma'am. Bottom left-hand corner of your screen.
There we go.
How are
Sorry
you?
about that.
It's all right. Your name?
Tara Lee Hazy.
Okay, we're getting a good connection. You're walking. Would you just stay right there for me, please? Thank you. Any resolution on this one, Mr. Barta?
Yes, Your Honor. We have resolved it. I do have authority to sign Ms. Hazy's name to it if the court permits. We filed suit for $2,626.38, but we resolved it for a reduced amount of $1,920 at $160 a month beginning June 10th, 2025, and $160 by the 10th of each month thereafter until the account has been paid.
You said by June 10th?
Yeah, the first payment's already been made, but so I'm just gonna leave it at June 10th because the first payment has been made on time and
You don't want to just reduce it to 1820, let's see, that'd make it 1760 and have the first payment due July 10th? I hate to sign orders that order somebody to do something retroactively, whether they did it or not. If that's a problem, we'll let it go.
I would ask to let it go just because I don't.
Okay, good enough. No problem. Ma'am, do you understand what he said?
Yes, I do understand.
Do you agree that you owe the 1920, but he's going to credit you the first $160 payment that was already made? So you'd make $160 a month payments beginning June 10th and the 10th of every month thereafter until paid in full. The judgment will reflect 1920, but that will not include the fact that you've already made your first payment that was due on June 10th. Do you understand that?
I do understand, yes.
And you agree to those terms?
I do agree.
Does Mr. Barta have your permission to sign your name to that proposed consent judgment?
Yes, please.
Do you have any questions for me at all, ma'am?
I do not. I appreciate the help and the assistance in working with me in this matter.
I wish you well. Good luck. He'll send that in today and then I'll sign it. You should have it in the next couple of days, okay?
Okay, thank you.
Great day. Thanks. Any more, Mr. Barta?
I have a whole bunch, but not till.
Okay, I got it. Midland Credit versus Zachary Dodd. Zachary Dodd.
Your Honor, the other two 9 o'clocks are in the breakout room still. We do, I don't know if the parties are here on the small claims at 9. 'Cause they would be in the courtroom.
They are here, but Mr. Hicks is in the restroom.
Okay. Do we have anything else ready?
Judge, I can ask them to come out of the breakout rooms if you'd like.
No, that's okay. That's all right. All right. Do I have anything else I can call right now? So Dodd's in the breakout room.
Midland just, they're coming out on Dodd right now.
On Dodd? All right, good enough. Midland Credit versus Zachary R. Dodd, 2500972. Good morning. Wait, we better wait for Mr. Dodd here.
Yeah, I'm waiting for him to come out. I'm messaging him right now.
Your Honor, leave the breakout room like I did.
Where is Mr. Dodd? Is this going to be a pretrial or did you resolve it?
We resolved the case, Your Honor.
Okay, are you
You can maybe skip me and go to another case?
Yeah, I will do that, but it's going to be a small claims. Come on up here, Mr. Hicks. Jerry W. Hicks versus Bates Chevrolet, 2501754. You two want to, whoever's here from Bates or wherever else, you guys want to talk? See come on up to the podium, Mr. Hicks. You're limping. Do you want to have a seat at the table?
I'm sorry, Your Honor?
I said you were limping on your way up.
I'm just old. I think I'm getting arthritis.
No, I understand. I'm just asking if you want to have a seat at the table.
No, I'm good. Thank you.
You sure? All right. Tell me your name, sir.
Jerry Hicks, Your Honor.
And your name, ma'am.
Good morning, Your Honor. Diane Boring from Bates Chevrolet, General Manager and Communication.
All right. I think you said Warren is your last name, correct?
Boring, B-O-R-I-N-G.
B-O-R-I-N-G. Diane Boring.
Correct.
All right. And your two names?
Sherry Graff.
G-R-A-F-F?
Yes, sir.
S-H-E-R-R-Y?
Yes, sir.
Ma'am, your name?
Megan Morris.
Megan?
MEAGAN.
Meagan, Morris, Morris.
Correct.
All right, today is the date scheduled on a small claims matter. Before we go on, I need to advise you of your rights. You don't have to proceed in the small claims division. Mr. Hicks is sued for $4,000. You don't have to proceed in the small claims division, though, if you don't want to, defendant. So in other words, if you proceed in the small claims division, both of you are giving up certain rights. The company is giving up certain rights, as are you, Mr. Hicks. You're giving up the right to seek in excess of $7,000. You're giving up your right to have a jury trial in this case. You're giving up the right to hire a lawyer to represent you in this case. And you're giving up the right to appeal my decision in this case. That is the same for Bates. Do you understand those rights, Mr. Hicks?
I certainly do, Your Honor.
Do you understand those rights, Ms. Boring?
Yes, I do, Your Honor.
Do you wish to give up those rights, Mr. Hicks?
I do not, sir.
You want to have the case removed?
I do not, I'm sorry. I want to proceed with the case.
So you waive the rights that I just enunciated? Are you sure? Yes?
Yes.
I just want to know, she has to take down what you're saying.
Okay.
Do you waive those rights?
Yes.
Ms. Boring, on behalf of Bates, do you waive those rights?
Yes, I do, Your Honor.
Are these two going to be witnesses?
Yes, I am.
I'd like you two to go right over there to the jury box. One of you can step in the jury box. That door pulls out and the other one can stand. Pull that door out there, please. And then one of you can go in there and the other one could stand outside. That is a microphone. So I want you to stand right by that microphone, Ms. Graff and Ms. Morris. I'm going to ask all of you to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Mr. Hicks,
I do,
Ms.
Your
Boring,
I do, Your
Ms.
Honor.
Graff,
Yes, I do.
Ms. Morris.
I do.
I don't know what this means. Does defendant failed to repair the 2003 GMC Yukon? You listed the VIN number. Defendant also refused to release that vehicle to the plaintiff.
That's
Oh,
correct.
did you pay them $4,000
I did, Your Honor. I have a receipt that I did pay the $4,000
to perform what type of work?
to repair my vehicle.
Yeah, I know. but-
Well, I didn't know exactly what was wrong with it. I took it to Bed Chevrolet on the 16th of December and dropped it off. And on the January 7th, Megan called me and told me that the vehicle had serious internal problems and it would be cheaper or it would be back by, they could order a new refurbished engine and it would probably cost about the same as for them to go inside and try to figure out what was wrong with it.
Okay, what did you tell them to do? That was January 7th of 25. Yes?
Yes, sir, Your Honor.
You took it in December 16th of 24, correct?
That's correct, Your Honor. On the, if the court allowed me, on the 15th, Megan advised me.
Megan? Ms. Morris?
Morris.
Okay.
She called and advised me that my vehicle would be ready in a couple of days. So I paid $4,000 for the average receipt.
What did they do to the vehicle?
Pardon?
What kind of work did they perform?
They were supposed to rebuild the engine, put in a refurbished engine, put my engine back together.
Okay. Do you agree with everything you said? Did they agree to put in a refurbished engine for the price of $4,000?
No, sir, the cost of the refurbished engine was $8,000. So we got a name drop, the vehicle was dropped off. We're not able to diag it until the 16th of January. Once the vehicle was diag, Megan did speak to the customer and explained that there's multiple problems with the vehicle and that we could try a refurbished engine. This vehicle has 251,186 miles on it, sir, and it is a 2003.
How many miles? 200 and...
251,186.
So she told him, is that right? Did you tell Mr. Hicks that you could try a refurbished engine?
So on the day that I had called, first and foremost, I talked to his son. It's his son's vehicle. I had talked to his son. I explained that we had to start here, that there could be, at the end of doing the internal issue that it had, there could be more wrong with the vehicle. Total was a little over $8,000. Through Michael Bates, you take down anything over $2,000, you have to have half down to order these parts, correct? So I did that. We take down a date of birth to authorize that because the customer obviously was not there at the time of the call over the phone. Then they put down the $4,000. We went ahead and did the internal work on the vehicle, and there was still issues that I had told them could very well possibly happen, and therefore it did.
And therefore what?
There it did. There was still more issues found after putting in the engine. There was not a couple of days. It takes almost 2 to 3 weeks just to get an engine. So,
All right, so the refurbished engine was never put in, right?
we did put it in because we completed that work.
I'm sorry, when did you complete that work?
January 9th, Your Honor.
And the car's been sitting there since January 9th?
Yes, Your Honor, because there were more issues with the vehicle, which we had told Mr. Hicks. So we were gonna do further diagnosis after the engine repair. By the time my technician pulled it in to do the other diagnosis on the vehicle, Mr. Hicks had canceled his payment. So we would no longer work on the vehicle.
So you didn't receive anything then from
So
Mr.
he canceled, he physically came into the dealership, did a $4,000 credit card transaction.
And then canceled it?
And then canceled it out from under us.
So you paid nothing?
No, sir, Your Honor, I have a receipt here. They still have my $40,000. I put in a dispute against Bates Chevrolet for the $4,000. And Bates Chevrolet responded back to my banker that I got what I paid for. They still have my $4,000.
We did dispute it, we did win, sir. So we do have $4,000 in-house after the back and forth.
How much does he owe you?
He owes us $4,000 right now. The vehicle still has upper engine issues, not the engine itself. But again, Your Honor, you're talking a $251,000 oath.
Well, I know, but
Yeah.
you want to pay another $4,000 and it's still not going to be drivable?
It's not 100%. It is not 100%, but that was.
How much was
not
that
guaranteed.
vehicle worth?
I don't have a value.
Do you have any idea how much that vehicle was worth with
I
$251,000?
think, I'm sorry, I don't mean to cut you off. Go ahead, sir.
No, I just wondered if you have any idea what that vehicle was.
I paid $3,000 for it a few months later in Arkansas.
A few months later, when? I don't know what you mean by that. In 2003 or just now?
No, I bought the car in '24.
Okay, so a few months before this, you paid $3,000 in Arkansas.
Yes. And I have notes here, Your Honor.
Where'd you get this from, a private seller?
I have notes here, Your Honor, that every time I talk to someone from Bates Chevrolet or went there and visit, I make notes. This is what I'm testifying from today.
I want to hear from you. I want to hear from you.
Well, when she mentions they, there is no they. I'm the owner of that vehicle. So if somebody else has something to say about what to do with that vehicle, that's not my business. I'm the owner.
Okay.
Okay. My name is Tim, Your Honor. On the 3rd of March, I called and left a message for this young lady here to call me to discuss the matter. Well, she never called me back. I did hire an attorney, Blake Speck, out of,
I don't want to know your conversations with your lawyer.
okay.
Okay, if he did something for you think is relevant, feel free, but
I do, Your Honor. He wrote a letter. He also called, talked to Sherry and Megan and asked for paperwork in regards to this vehicle, that's what they've done. Neither one of them responded to him at all.
all right, but we need
I have
to,
an attorney today.
no, I get it.
But when she called me and told me they had an electrical problem, I said, we didn't have an electrical problem before. Started. And about that too, Your Honor. I went to pick up a battery there one day. Megan said, he'll have a mechanic driving into the bay while I get the battery out of the back seat. Probably 10 minutes later, the mechanic comes in, and I have a date when this happened.
I don't want to hear this.
Okay.
It's okay, I'm going to come back. But I want to know,
May I speak on it?
no, I want to ask a question first, and I'm not sure how I want to phrase it, except to say, it sounds to me like you initially promised, and I'm asking you if this is true or false.
Absolutely not, Your Honor.
I didn't even ask you the question.
Okay.
How do you know? You didn't say that once we refurbish the engine, that, or get me a refurbished engine, that this is going to operate adequately?
A vehicle with 251,000 that is not running, sir, we can't guarantee anything. And the vehicle was for his son, and I think he was just trying to get his son back on the road. We don't want to take anybody's money.
I know, but if he paid $3,000,
Total cost around was $5,000 for that motor.
didn't you tell me you paid $3,000? No, I know $4,000, but didn't you tell me you paid $3,000 for the car in Arkansas in '24? That's what I'm referring to.
Yes.
So we're up to so now he's spending another $8,000 and the car isn't still drivable? It's not ready to go? I mean, that's like, I don't know what that's like. I mean, that seems like really bad business.
They still have my vehicle.
May I speak, Your Honor?
Yeah.
I completely understand your feelings. And
Well, I want to.
initially, when I read this, I truly understand how you feel. However, if he's adamant about fixing a car for his son, all we can do is say this could happen or this could happen, and ultimately it's his decision. I would not invest that kind of money in a 251,000 mile car.
Did you have the discussions with him or
No,
did
sir.
somebody else? Who had the discussions with him?
Megan.
What did you tell
I did, when I called him and told him what was going on with the vehicle.
him?
that
And
he-
he'd already paid $4,000 down.
I wouldn't have known what he paid to buy the vehicle, that's not. it's
No,
not-
no, no, wait, no, I'm not talking about what he paid to buy the vehicle. That was a different issue.
Okay,
He'd already given you guys $4,000.
but when I sold the job and told him what it needed, I told him it was $8,000. I have to have half down to order the parts. The
Right.
parts are a little over $4,000.
Right.
This is by any customer that comes into me.
Right, this is on the 16th, you had this phone
I had
conversation.
this conversation with this gentleman on
And
the
what did
phone.
you tell
Well, first I had the conversation with his son. We need to be open and honest. I told the son, because the son is who I initially had the telephone number in communication with. It is his vehicle. Whether it's in his dad's name or not, I don't know that. So I had the conversation. His son got extremely rude with me to the point where I didn't feel comfortable any longer talking to him on the phone. At that point in time, he hung up on me. Mr. Hicks had now called. That was my line of communication. He apologized that his son was extremely rude to me and called me every name under the sun. And he asked, what is going on with the vehicle? I said, I had told your son that it came in for a check engine light and the vehicle wouldn't go over 10 miles per hour. It had internal engine failure. This is the cost for it. This is what you have to have down. This is where we need to start. Starting as it means we could put this engine in and you very well might have more issues with your vehicle. I do not know. But we need to get it up and running, at least with the engine in it, because that's what's showing that we have to do first. This gentleman had told me, absolutely, here's my birthday to authorize this job, which everybody has to give a birthday if you're not there in person to sign or to give, we take authorization over the phone with the birthday. I have gotten his son's birthday and his birthday. He agreed to the $8,000. Came and gave me $4,000 down. We put the engine in it, test drove it, still has issues. I called him, let him know that, and now here we are.
Jeez.
I didn't
Is
pursue
what she said,
anything or promise anything.
is what she said just true?
It's not, Your Honor. She has never mentioned $8,000. I think, Sherry, I talked to her one day, and she told me there was no compression in number 1 and number 7 cylinder, and that my engine had a warranty. I said, well, you bought the engine. You get a new engine in here. $8,000, I think Sherry mentioned $8,000, and I said, what are you talking about, $8,000? The price of the motor. Where did you come up with $8,000?
Wait a minute, slow down. So you're disputing her testimony that she.
Absolutely, that's
what, you gotta let me finish. You're disputing her testimony that she said it's gonna cost $8,000 and we need half down or $4,000. You're disputing that?
I certainly am, Your Honor.
So what did she tell you when you gave her the $4,000 before you gave her?
I didn't talk to her.
Let me finish. Let me finish.
I'm sorry.
what did she tell you, or Sherry, or whoever you want to tell me, what was conveyed to you as to what would happen once you gave the $4,000 payment to them?
Okay, Your
Or
Honor.
did they tell you 5,000 and you got a new engine?
No, Your Honor, at the very beginning, Megan told me that the engine, refurbished engine would cost $5,000. On whatever date I just mentioned, she told me the vehicle would be ready in a couple of days. So I went into the cashier on the credit card, paid $4,000 down, knowing I still owe $1,000 because I had $1,000 in the bank.
Did you have 1,000 what?
That I had $1,000 in the bank. I
Okay.
paid them for it, total price was $5,000. But after I made.
You told me it was 5?
No. I told him I need half of what the total was. The total was a little over $8,000. He came in and paid half of it, which was $4,000 even. I don't know where any of these extra numbers are coming from.
Go
Not
ahead.
a clue.
Your Honor, anybody with common sense knows that a refurbished engine does not cost $8,000.
Well,
Everybody knows that.
well, I gotta tell you, I'm not savvy with vehicles. You can say that. I don't know that I would know what a refurbished
I am,
engine
Your Honor.
costs.
I used to own a junkyard too.
Well, you know dealerships charge more anyways,
I
right?
know. They don't charge $4,000 more than what the motor's worth. She gave me a price of $5,000. I never heard $8,000 till I went in and seen Sherry about where my vehicle was. She said, well, we're afraid you're gonna steal the vehicle. So
Steal the vehicle?
Yeah, they thought you were gonna steal the vehicle.
How are you gonna steal, how would he steal the vehicle?
No, Your Honor, what I said is, he had disputed the charge at that time, the 4,000, and we had put in a disputal for that, and he wanted to pick up his vehicle, and I couldn't release the vehicle without payment. Grace put $8,000 into the vehicle,
Right.
so.
That's
we
not
did it.
true, Your Honor.
Yeah. And if I may, can I speak?
Sure.
Not only did we do an engine, we did, oil cooler lines, we did other repairs as well. I don't have the paperwork in front of me, but we did other things that led up to the $8,000 that we
The
approved.
equivalent though, I wanna tell you, paying $10,000 for a car and then going out and paying about $25,000, $26,000 in repairs to get the car working, it just doesn't make any sense to me that somebody would buy a car for $3,000 that I can't believe would Blue Book for $11,000. And now he's got himself in a position, or at least a situation's created, where he's got to pay $8,000 more and it still doesn't have a drivable car. That's what you're telling me, right? There's other issues to deal with?
He does have other issues, Your Honor, but he also had it at 2 other repair shops before it was at ours.
Is that true?
Sorry, Your Honor.
Did you have the vehicle at 2 other repair shops before? Let me finish.
Sorry.
You gotta stop doing that. See, I don't want to sound rude either, but she's got to take down what is being said here, okay? Everything's being recorded.
Yes, Your Honor.
Did you take the vehicle to 2 other repair shops before you took it to Bates?
I took it to Auto Dock, down the street. That was not the problem. I took that there.
Wait a minute. What do you mean?
I was having other little issues, electrical issues, the radio. And anyway, I took it to George's, which is just on the other side of West Road. I left it there for a week in the parking lot. He never touched it. So I was able to drive it down to Bates Chevrolet and left it in their parking lot and talked to the mechanic or the associate in there. He said it'd be about a week before we get to it.
When the mechanics performed this work, did anybody go out and attempt to drive it?
After the repair was made?
Yeah.
Yes, sir.
And they still said what kind of problems
And that's
exist?
when he had a 3-cylinder misfires on top of the engine. Yes.
Well, this is a mess. So he's giving you 4, you want 4 more, and he still doesn't have a car that's operable. and he paid $3,000 in 24 for a car with 251,000 miles.
And it was his decision to put that money into that vehicle. So-
Well, but you're the experts, aren't you?
Well, we.
I mean, that's a little like saying to your doctor, hey, I want you to do this, and the doctor knows it's, or a lawyer, whatever it is. You guys are the experts. Couldn't you tell by running all these diagnostics as Ms. Boring was talking about as to what exactly was wrong with the vehicle? So you could say, this is the problem, this is the problem, and that's the problem, and that's going to cost X amount of dollars. It seems pretty simple to me. Maybe I'm making it too simplistic, but doesn't it seem like that's the way it should have gone about?
It's really not that simple, Your Honor. So we did have to get the vehicle running with an engine. It had 251,000 miles. We did advise him that there may be other issues. He had electrical issues. He had it pour down the road. He still has electrical issues. I mean, there's a lot of problems with the vehicle, but he did authorize to repair it for the engine.
Mr. Hicks?
Your Honor, Megan told me that my vehicle would be ready in a few days. All it had to be, is her words, just buttoned up. That was her words.
All that way?
That all it needed to be was buttoned up. That's what her words were.
Do you have any estimates, written estimates for him? Did you give him any written estimates? I'd like to see those.
Yeah, I would too.
Did anybody say on there, hey, no guarantees, might need further work? I want to see the documentation. I mean, you guys are the experts here. It seems to me that on estimates, you would have noted there still may be further issues to deal with, even if we put in a refurbished vehicle. That's the way I'd see it right now. Let me see what you got. Do you have any notations like that on any of this paperwork?
All I have here, I do have a written estimate on here. Well, it's the total for the estimate. You'll see a couple on here.
Tell me what the total for the estimate was. Read it to me. Just you can read it right there. Read it.
8,500 for the engine, intake manifold, exhaust bolts, the gaskets, the engine mounts, the coolant hoses. And then we also did a power steering pump, engine and bolts, necessary bolts and fluids.
Did anybody say there still may be other work that needs to be done?
When Megan spoke to him on the phone, this is our starting point. We always say that because especially when we don't have a car that
You should
is.
put it in writing. Did you say that to him?
I did, 100% I did. I said, sir, this is where we are right now with it. We have to start. My keyword is start with an engine. There very well could be more issues with the vehicle, but we have to start here. Here's the total. This is what I need down, and I need your authorization to do so. Well, how do I get that? With your birthday. I have his birthday. I'm here written, circled, and I even have the total.
Was all that work performed
Yes.
that you just wrote, that you just read to me?
Yes.
And you say they didn't tell you that?
No, sir, Your Honor, they did not. And I always say, it's easy to remember the truth, but it's hard to remember a lie, so. Somebody's not telling the truth here, and it's not me. I mean, I'm telling the truth.
Did it have on the estimate, you said 8,500, right?
Yes, sir, it is.
Was that before or after he made the payment?
That was before.
And did you ever give him any kind of receipt indicating that the balance was going to be 4,500 after he paid the 4,000?
No, I do have to receipt for the $4,000 down and his date of birth. Again, that's what we do when we get authorization. If the person is not in front of me, we get a date of birth.
That's it, Your Honor.
Yeah.
All this other stuff that's adding on here, this is the first I've heard of that. Power steering.
Well, but you did get an estimate for $8,500, right?
No, Your Honor, the price was $5,000 for a
Did
refurb.
he sign that estimate?
I do not have a signature, Your Honor.
When was that? What is that dated?
This is dated 3/20, oh, I'm sorry, that's his birthday. The only date I have on here is 12/16. That's the day we wrote up the vehicle.
We have the date of when he put the $4,000 down.
Wait a minute. You didn't know 12/16, you said?
That's when I dropped it off.
That's when he dropped it.
I know, but I thought you didn't know until after the beginning and you called him on the 15th or 16th of January. Didn't we already cover that?
So 117 is the date I have.
Let me see the document. Let me see the document. I'm sorry this is taking so long, everybody.
Well, Your Honor, I just want the truth to be told here, and it's not been told.
So what do you think you bargained for? See that, please?
I'm sorry, Your Honor?
What do you think you bargained for? An operable car after you gave him 4,000 and you owed him one more?
Your Honor, then thanks Chevrolet, I thought was a reputable dealer, I assume they still are. But when I took my vehicle in there and was told that it needed a refurbished engine, or they could go into the motor and take it all apart, and Megan said it'd be just as well, go ahead and buy a refurbished engine for $5,000. I said,
Megan told you that?
yes, sir, Your Honor, I swear she told me. So I said, well, go ahead, I'll have a new engine in my car. Then I get the call, it's gonna be buttoned up.
There's just scratches and notes here.
All this other stuff. Yes, I did sign for.
Labor 3,800, it looks like you're saying estimate, right? 8,500 by Jerry Hicks, date of birth, and you have his date of birth on here.
I also have a son's date of birth, because that's when I started talking to, before it went south with them.
I did sign the honor, had the $5,000 motor put in. Some of the stuff I have no idea what.
You signed what?
I'm sorry, Your Honor.
What'd you just say?
I did sign a paper. She had me sign a paper for the refurbished engine at $5,000.
Let me see it. Do you have a piece of paper that shows me that?
No, she has the paper.
Do you have that paper?
It's what's in front of you, Your Honor. He didn't sign it. He gave us his date of birth.
Well, maybe I'll take it.
Slow down, everybody, please. What is it? I mean, these are scratchy notes, my lord. What am I supposed to know here? I mean, you got $5,500 written in circles here. What does that mean?
So, just those. The $5,500 was just for the reman engine, and then he added on the power steering pump, the lower trans lines, the left engine mount, and necessary bolts and gaskets. And I do remember you authorizing that because you had argued with me that nobody, or you didn't argue, you just told me that no one else had found the leaks at the other place. And I said,
Do you think he owes you money now? You didn't counterclaim. You guys didn't file a counterclaim. So this car's just been sitting in the shop for all this time? What a mess.
Can I speak, Your Honor?
Yeah.
I have no idea where my car is. It's not in the shop. I don't know where my vehicle is at. Someone mentioned, I don't know who mentioned it, but one of these, I don't think it's this young lady here, somebody mentioned that they could get a quick claim deed of a mechanic's lien on my car and take it.
Is the car still at the shop?
yes, Your Honor, and we have
If I went over there right now, I will see the car at the shop.
So we have a building next
True or
door to us.
false?
Yes, true,
Okay.
true.
I know how this should resolve. I'm just trying to think of how I'm going to do it. Well, if you don't mind me saying, as an advice to you guys, somebody needs to keep better paperwork here. This looks like scratch notes that I would have used in third grade. I mean, I can't even read this. And you got numbers all over here, like $5,500 it says, and it looks like it says doing this. What does that mean? Who wrote that? 5,500.
Mine.
And somebody else wrote 114,000 miles, it looks like, right? Do you have an extra copy of this?
I'm reading it with you, yes.
What does that mean? 114,000. What does that mean? Miles, it says next to
Oh,
it.
that's probably what the remand engine came with on it.
That's what those miles are. The word absence is miles. That's what
Okay, what's it say, $5,500? What's that for?
That's just for the aftermarket. That's just for the price of the motor. That's how much the motor cost alone. That's why I'm really confused when it's just the fourth. How is that when the part alone was over 5,000?
I had something, Your Honor.
Yeah,
Maggie did tell me that there would be tax on the $5,000.
that's 300, right?
I don't know what it was. But she said it was $5,000, and then later on, I was talking about it, because, I mean, they're nice people, you know. And she
Oh, I
said,
get it.
There's gonna be tax on that $5,000. That's what I said.
Where does it say anything on any of these estimates? I'm gonna ask you to look at this and tell me where it says anything about $8,000.
Right up here, it says 8,500, okay, by Jerry Hicks, date of birth.
Yeah, but I didn't say,
4/1/47.
nobody told me anything about 8,500. She told me that he owed another 4,000.
Mhm.
There's a difference. He gave him 4, I can do math, 4,000 and 4,000 is 8. Why did somebody write 8,500 on here?
Because I did tell him that it was $8,000 plus the tax.
Well,
So
that,
it was- I mean,
what,
we always round up just in case of, there's additional parts at the end, always happens. But that circle that is right there with his date of birth, everything on that is exactly what was authorized.
well, you have his date of birth on there,
And I
right?
have a son's also.
I know, I see that.
That's it, Your Honor.
Yeah,
My son has nothing to do with this. He's my son. As far as authorizing this or authorizing that,
what do you intend, let me stop you a second. What do you intend to do with this car? You're gonna just assert a mechanics lien? Is that what you guys are gonna do? And
Your Honor, our business reputation is worth more than anything. I do believe there's confusion because if the cost of the motor is over 5,000, we have to pay our technicians.
Well, I get it.
Feed their families, there's labor involved. And I don't know if he's forgetting or what. I was not.
I find him to be believable, and I think he's got enough common sense, and I believe he's got enough common sense to recognize that you don't buy a car for 3,000, put 8,000 more into it on the IFCOM, that it will drive appropriately, and if it won't, that it's gonna cost me more money. That makes absolutely no sense to me. So I can tell you, I think,
Your Honor, may I speak?
yeah,
Please don't forget that he did take it to 2 other shops. And
He-
he was frustrated
he
with the other 2 shops.
well, the first one he took it to was something about a radio, and the second place it sat there for a week, I thought he said, at George's, and they didn't do any work on it, and he wanted to get the car running, true or false? So I think,
There was parts.
wait, I think, in fairness, as strange as this might sound, I know it should happen, I just am trying to figure out a way to do it because you didn't file a counterclaim, okay? And I don't want to spend all day on this, but I want to do the right thing. I think what I'd like you to do is you should file a counterclaim if you think he's got another $4,000. Jennifer, I want you to listen, please. If you think he owes you another $4,000, you should file a counterclaim. And then, I'd like you to bring in the mechanics. I'm shocked that they can't figure out in the beginning how much money it's going to take, at least in a ballpark. I find it incredible to believe, like I said, that he would pay an extra $8,000 or $8,500 on the IFCOM that this 251,000 mile car is going to operate won't operate without the potential of further work. You can't just say, I'm going to fix this and this is what it is. and then not say, well, we don't know if it, did anybody lead you to believe that this was going to require further work?
No, Your Honor, did not.
Yeah, I don't believe. Jennifer, I'm gonna send them down and I'm gonna have Bates file a counterclaim. If you think he owes you $4,000 or $4,500, you can file a counterclaim. And then I think we need to hear from the mechanics.
I'll bring the mechanics.
Now, I'm no expert. I hope you're gonna have some good questions for him, okay, Mr. Hicks?
Yes, may I get the possession of my vehicle from this show?
I can't do that yet. I'll move this case for you, though, I promise you. I promise you. I will move this case quick. Jen, when can I do this? Can I do this, if you think you can get the auto mechanic, I could do it next Tuesday or Wednesday.
Perfect.
No,
What?
on the 23rd, you have, yeah, we could do it at the end of your landlord tenants next Monday.
Good.
Would that work?
Sure the mechanic's gonna be available?
I'll make them available.
We'll adjourn this to June the 23rd at,
11:30.
and you go down and prepare a counterclaim.
Got it.
Counterclaim. And then they're gonna serve it on you. I just want you to be aware. They think you owe them $4,000 or $4,500 or $44,000 plus tax, which I guess would be another $480. I want copies of that, and then I want you guys to but John's bringing down some copies, Jen, and I want to make sure those are given to me, okay?
Okay.
That's taken off.
Yeah, but we're not going to resolve it today, so make it
Would it
short.
be possible for you to have Bates Chevrolet bring papers that I signed for work to be done?
Yeah. Well, they're saying they don't have them. They just have this approval order that was done verbally, and that's why she took your date of birth. But yes, any and all documents in any way related to this transaction, you are to bring here if they are not here today. Okay? So bring all the documents related to this transaction. Bring them, the mechanic or mechanics that worked on this. And we'll do it next week at what time, John?
11:30 on the 23rd. My only question, Judge, is service. If we could.
Can accept service, right?
Okay.
Yeah, you just accept service. Wait for them to fill out the counterclaim. Let's not make this any harder than we need to, and we'll go from there, okay?
I thought it was gonna be an easy case, but
Well, I don't think it's as easy as maybe as, that's all I can say. Thank you all. Thanks for your patience. Okay, let's go on. I gotta take one of these real quick. I gotta get GTSC Warehouse. Are they here versus Adkins, Christopher Adkins?
Yes, Your Honor.
2404976. Mr. Adkins, your name, sir?
Christopher Atkins.
Ms. Kuzi, are you on this?
Yes, Paige Cruz on behalf of the plaintiff.
Ah, good to see a smiling lawyer. All right, did you two talk and resolve this or not?
We did have a chance to speak and we could not come to a resolution as of today.
What's this about?
Yes, Your Honor, we had filed a claim of alert possession action. The date that we had filed suit was in December of 2024. And we were up to the point where we were able to submit a default request and entry. And defendant did end up filing an answer about May 7th. As of today's date, we did speak, there is no tribal issue of fact. He did indicate that he is going to be trying to file a bankruptcy, Chapter 13 bankruptcy, but we have spoken and he agrees that he owes the amount. There's no tribal issue as to that. He does not dispute it. Plaintiff would be seeking to enter possession judgment today, as there's no tribal issue. He agrees he owes the amount. It's just, tactic for him to delay this matter. His balance is exceeding about $15,000 as of today. He's indicated that he's going to be trying to file Chapter 13 bankruptcy. We tried to come to a resolution, but we could not,
Mr. Adkins, you need to talk to a lawyer, sir.
Oh, yes, Your Honor. I have one. I'm in the middle file. I had a delay in my tax return filings. I just filed them. They just went through. And I also did the financial class for him. And I spoke with him in the middle of our intermission.
I don't need to know what he tell you.
Okay. I don't know what to do.
Hang on just one second.
I don't know the balance. The balance sounds a little high to me, but
Just
I
wait
don't know.
1 second. Just wait.
Yes, sir.
Let's adjourn the pre-trial. I'm gonna adjourn it for 3 weeks. You can go consult with a bankruptcy lawyer and anybody else you want to. Jennifer, give me a new date, please.
The 15th, Your Honor,
At,
8:30.
that is what day of the week? A Tuesday?
Tuesday, yes.
July 15th at 8:30 will be the pretrial. You seek a lawyer, Mr. Adkins, okay? And I'm not gonna
Yes,
take
Your
any
Honor.
action on this at this time. And if you guys want to prepare a consent judgment, I just think he needs to get a lawyer on this, okay?
If we could get a motion hearing date, plaintiff would then intend to be filing an MSD. I did speak to him. He confirmed that he is speaking to a bankruptcy attorney, and he confirmed that the attorney is not representing him in this case. So I did confirm with him before I spoke to him, and he confirmed that from the beginning that he wasn't representing him, and then now he keeps going back and forth and saying, oh, he may be representing me. So he's just, playing a tactic to delay this matter, but he did confirm before I spoke to him that he's not being represented by an attorney on this matter.
No, I don't have any doubt that you wouldn't have spoken with him if there was a lawyer representing him. Let me be clear about that. I'm just going to give him 3 weeks to regroup. He's got some equity in that. I don't know what his financial situation is. It's a little more complicated than a regular debt collection case. You have July 15th. Bring your lawyer or you show up, but I'd strongly suggest that you bring a lawyer, okay?
Yes, Your Honor.
That's what we'll do. Okay? Ms. Kuzi, you're looking like you're not satisfied, but join the chorus of those who come into a courthouse and leave unsatisfied.
Motion hearing days, because we do intend to file a motion for summary disposition. We could get a date today.
Yeah, you call the civil department. I'm just adjourning the pretrial, and then you call the civil department. They'll give you one. It's probably going to be on Tuesdays, right, Jen, for the most part?
Yeah, yep. I have July 29th. I could give her right now at 10
So you can
o'clock.
take July 29th if you want. You can set it any time in the morning, okay?
Okay, thank you, Your Honor.
Have a great day. Thank you both. Midland Credit versus Zachary R. Dodd, 2500972. Mr. Dodd, your name? Jeez.
He's on mute, Your Honor.
What's that?
It looks like he's on mute.
Nah, he left. He's gone. I don't see him anymore. He was here for a second.
He was just here a second ago, yes.
All right, Mr. Dodd, you have to start your video, sir. Bottom left-hand corner of your screen. Mr. Dodd? Jennifer, can you chat with him and explain to him? Recalling Concord versus Mount. 2501975. Names?
Good morning, Your Honor. Craig Gallup, 26300.
You're looking at your watch. Did I keep it?
Mount.
Did you guys resolve this?
We tried, Judge. Unfortunately, we're too far apart right now. I tried to come up with some solutions here on both sides of the equation. There was just no solution where we can find some middle ground, unfortunately.
You're not close?
No, if you want to go off record, I can kind of tell you where we're at. I just don't know if some of this discussion should be part of the record.
Well, no, I know, but I'm not going to get involved in this if you aren't somewhat in the same ballpark. It sounds like one of you is in Juneau and the other one's in Fort Lauderdale. I mean, if it's not close, I'm not going to waste your time and I'm not going to waste Ms. Mount's time.
I think a little discovery probably would help. We just have some severe issues of fact here. I think maybe once we have people that are under oath to submit some statements here, I think that may affect maybe her decision.
Well, I have to decide whether or not I'm going to remove the case to the to the circuit court.
Well, if you did, Your Honor, I mean, I know you're not hearing the motions today, but it would only be the counter complaint that goes based on.
No, I know.
Yeah.
I know.
And I explained that to her today.
I know.
2 tracks.
Yeah, you understand that, right? You look sad. What's wrong?
It shouldn't even be here.
Well, you filed counterclaims.
Choice.
There was hundreds of pages in these documents. I took this home, believe it or not, and
I'm sorry, it was Father's Day too.
it's all right. There were there was a lot of
Part of it way back when I think there was miscommunication on her end. We believe she was giving the answers and that wasn't satisfactory to her. That's what heightened things up over the years. And the board of management just got sick of what they saw as defamation and not following internal procedures and going to state federal agencies and making false allegations, even under oath, of collusion and misappropriation of funds. And we just can't have that. Our reputation, Ms. Turner's here, Your Honors, dealt with her for a number of years. And I think the reputation of county court is excellent. They try to provide affordable housing for people.
One of the things he said in his brief is that you said you wanted to move out anyway. Did you say that? I didn't read it, but you did say that in your brief. You were talking about in reference to the mold and saying she complains of mold, yet indicates she wants to leave anyway.
This was years back when the original mold, when she had to go to this was in the hotel, and then they had to do some rehab, some remediation.
There's two mold issues.
It was back, this isn't recent, Judge. This goes back some time. This goes back to 2019.
And it's still on hold.
I think you have to do some discovery, Your Honor, maybe at that point.
I don't think I can do that without deciding whether or not the counterclaim should be transferred.
I agree, you want to make a decision on that, Your Honor. But we will have to conduct discovery in the district court case as well. And maybe after we do some discovery, maybe a facilitator can look at some of the stuff and be able to force parties in.
Facilitator, yeah, but you know how much facilitators, you can pay $350 each or $280 each or $300 each per hour.
I don't know if this court is so inclined, but I know some district courts, we've had, I think, some other magistrate help out or something.
I could do it. This is a jury trial. I can get involved in the settlement, but I'm not going to do that unless and until I decide, given the fact that you're so far apart, that the counterclaim should not be transferred, and I can't say that right now.
On its face, it's still deficient. We probably will have to file a motion at the circuit court for a more definite statement at some point. But the idea of the bifurcation, I'll leave it at the court's discretion, but based on how she is written as a layman, it's not right for a response.
Well, I think it got turned wrong. That wasn't my how it happened.
What do you want?
And for them to acknowledge that my upstairs still has a hole in it. And
A hole.
I have a hole in my floor. There was a hole in the floor. They were supposed to replace it upstairs. There was mold up underneath of it. Instead of replacing it, they covered it with a sticky towel, put mud over it, and then the linoleum.
When did this all take place?
This was back in 2000.
Well, okay.
Well, the thing.
Wait a minute, wait, slow down. This was 2019, right?
But yeah, and then I got put on a waiting list.
Right or wrong? 2019.
Yes.
You've been living there for 6 years and now you're bringing this up?
But no, because I was been told I've been on a waiting list, and then.
For 6 years?
I've been told I've been on a waiting list since it was supposed to be fixed. I'm not the only one either.
The floor issue, there are floor issues in other units, Your Honor. We do have a waiting list, just for the actual top that will go on it, but I'm not aware they're still being mowed in the unit. There was an uninhabitable condition. She wouldn't be there right now.
You've been on a waiting list, you're telling me, for work to be performed for 6 years. I just want to make sure I understand.
Yeah.
It hasn't been that long, Rich. There's been a wait list. It's been a couple of years after COVID. We have a lot of properties that's only 400 units.
I know, maybe they better get more maintenance people. I mean, come on, 2 years? I don't care what it is. Right?
I know people are having.
Well, it was hard to get them to even acknowledge it again.
I'm adjourning the pretrial. Jennifer, pick a date with them, please. And I'll adjourn the pretrial. I'm going to figure out what I'm going to do. Maybe I'll come over there then. Maybe you guys can talk some more. Good. That's unacceptable. Give them a new date down in the hall, will you please, Jen?
Yes, Judge, but how far out do you want me to go with it?
3 weeks.
3 weeks? Okay.
When was this case filed?
It was within the last 30, 45 days, I think, Judge.
Okay. We'll give you another pretrial date. Let me think about this one, okay? I'll see you guys back whenever you're both available. But go down and talk to her about the date. Thank you.
Thank you, Judge. No, just go to the question. I'll stay.
Chandler, what are these? You too. What are these here?